Good morning, everyone. Today is Monday, September 14th, and I want to welcome everyone to our hearing today about antitrust issues here in New York. I am the chairman of the Senate Committee on Consumer Protection. I have with me the Deputy Majority Leader of the Senate, Mike Gianaris. I have Senator Jessica Ramos, who is a member of the Consumer Protection Committee, as well as Senator Zelnor Myrie as well. Uh, so I have the immense responsibility to protect the welfare of 20 million consumers here in this state. Our economy is based on free enterprise, and antitrust laws are essential to this, which is why Senator Gianaris and I uh, are holding this hearing today. It is to identify competition problems here in New York and to examine how legislation can best address this. Here in New York, we have companies which I don't even need to identify that are crucial for commerce. Because these companies control access to our everyday life, their actions, whether good or bad, have a very big impact on our economy. They have the incentive and ability to exploit this power. They can charge exorbitant fees, impose oppressive contracts, and extract valuable data from the people and businesses that rely on them. Let's take, for example, the day in the life of a typical American as described in an article found in The Atlantic. How long does it take for a person to interact with a market that isn't nearly monopolized? She wakes up to browse the internet, access to which is sold through a local monopoly. She stocks up on food at a superstore, which owns a quarter of the grocery market. If she gets indigestion, she might go to the pharmacy, likely owned by one of three companies controlling 99% of that market. If she's stressed and wants to relax outside the shadow of an oligopoly, she'll have to stay away from ebooks, music, and beer. Two companies control more than half of all sales in each of these markets. There's no escape, literally. She can try boarding an airplane, but four corporations control 80% of the seats on domestic flights. In order to protect its power, companies have either bought, copied, or blocked access for any actual or potential rival. This only hurts the consumer, and that is why we're holding this hearing. I want to thank all the witnesses that are going to be testifying today, as well as central staff and all our senators and members of the legislature that are here to ask questions. I want to now turn this over to Senator Mike Gianaris for his opening.
Thank you, Chair Thomas, and all my colleagues who are participating. We're having this hearing for a very simple reason. Our antitrust laws are broken. They were written over a century ago. They were intended to deal with an economy that no longer exists, and many of the abuses that we see today were not even contemplated back then. There's no question that the tech economy and the innovative economy that we have today has brought many benefits to the residents of this country, but there are also perils involved when they dominate so much of the economy and so much of the market. They are spreading ever more into new facets of our economic lives and even our political lives. We saw congressional testimony just a few weeks ago that highlighted some of these problems. I should point out that it's unfortunate that none of the companies that we invited to appear individually chose to attend today. So if they opt not to have input into what we're contemplating here in New York, that's their choice. But we certainly intend to have a thorough examination of these issues and move forward in New York in a way that will set the tone for the rest of the country. The antitrust laws we've had in this country have been slowly chipped away, even since the time they were written. And so it is long past due for us to update them, put some teeth into the laws, and empower our regulators to do the job they're supposed to do for New Yorkers. So again, thank you, Chairman Thomas, and I look forward to the testimony today.
Thank you, Senator Gianaris. Senator Ramos, would you like to say a few words?
Sure. Thank you, Chair. And I see our Attorney General is here. Thank you for joining us this morning. I, of course, am speaking from a position of, a member of the Consumer Protection Committee, but also inevitably as chair of the Labor Committee. I always have to have that hat on. And of course, think about the implications of these big corporations, the implications on working conditions and on wages. And you'll hear more about my perspective a little later, particularly as a state senator with an Amazon warehouse in my district. I have been able to see firsthand the effects of, or the execution of the thoughts of the richest man in the world. And it's quite something. So I'm looking forward to hearing testimony and asking my questions. Thank you so much.
Thank you, Senator Ramos. Does Senator Myrie want to say a few words before I start with the first panel?
Chair Thomas, please continue. And just as a heads up, I'm sick, so we'll probably not be asking questions. Thank you.
All right, will do. Thank you and feel better. And now we go to our first panel, the New York Attorney General, Letitia James, who's with us today to talk about these issues. And thank you so much, Attorney General, for being with us today. And you may start at any time.
Thank you and good morning. My name is Letitia James and I'm the Attorney General for the great state of New York. And the central question before us is whether or not the enforcement tools that we currently have for antitrust enforcement are adequate to meet the changing marketplace, whether or not we are in a position to protect consumers against predatory and anti-competitive conduct, and whether or not our existing toolkit can ensure a fair and open marketplace and fair competition. That really is the central issue today. And so I really want to thank you, Senator Thomas, Deputy Majority Leader Gineris, and of course, Jessica Ramos, and one of my senators, Senator Myrie, and I hope that he feels better, and the rest of the committee for inviting me here today to discuss the 21st Century Antitrust Act, sponsored by Deputy Majority Leader Gineris. I support passage of this act because it will give New York's antitrust laws the scope and the flexibility needed for effective antitrust enforcement in this era of increasing economic concentration. New York's antitrust statute, known as the Donnelly Act, was first enacted in the 1890s. Might I add, it was enacted before the Sherman Act, which is the federal statute, at a time when the power of giant corporations were the most political and economic issue of the day. For the most part, if you look back at history, it talks a lot about trust and basically trying to have some control of all of the giant trust in this country. The state legislature was concerned that these corporations were using that power to destroy competition and exact unreasonable charges from the people. Since that time, the antitrust laws have been, in the words of the United States Supreme Court, a comprehensive charter of economic liberty aimed at preserving free and unfettered competition as the rule of trade. Competition breeds innovation, competitive pricing, and consumer choice. And by protecting competition, our antitrust laws have promoted innovation and thus allowed the United States to become the home of some of the most influential and innovative companies in the world. Enforcers have relied upon these laws to prosecute cartels for fixing prices or dividing market territories, both within the state and internationally, to stop companies like Microsoft and New York City's tour bus companies from monopolizing the markets in which they operate, and to block mergers between close competitors such as Anthem and Cigna or Staples and Office Depot. However, in recent years, accelerating economic concentration in certain markets has harmed consumers, workers, as Senator Ramos has mentioned, small businesses, and competition. Companies have prevented new competitors from entering the marketplace by using exclusionary tactics. They've priced their products below cost to drive competitors out of business, particularly small businesses. They force consumers and other companies to buy products or services they might not otherwise have bought. They prevented workers from seeking other positions with higher wages, and they've used their power in one market to gain competitive advantage in another market. These practices go beyond aggressive business techniques. They are deliberate efforts to take advantage of market power to hinder effective competition and harm consumers. Significant concerns have been raised about large internet platforms in particular, which have come to dominate many aspects of our economy and our personal lives. We are actively investigating many of these practices and will use our existing authority to the fullest extent to address these harms. We are also working with Justice and FTC on other investigations. However, the Donnelly Act has a number of outdated and ambiguous provisions, as was mentioned by Senator Gianaris. And if enacted, the 21st Century Antitrust Act would correct these problems and strengthen our enforcement efforts. For instance, it would update maximum criminal and civil monetary penalties that were last set 45 years ago. And because of inflation, these penalties are now too low to provide a meaningful deterrent. In fact, they're usually seen as the cost of doing business. Likewise, it would increase the statute of limitations to criminal violations from 3 to 5 years, in line with comparable felonies in New York. An important gap in the Donnelly Act is that it does not explicitly bar unilateral or single company anti-competitive conduct, even if committed by a monopoly. In contrast, the Sherman Law, Section 2, and the laws of at least 32 other states prohibit monopolization. It says time's up. Should I continue?
Letitia, you're still muted. Please quickly wrap up.
Thank you. Your act would fill the gap. The Act's abuse of dominance provision is a core element of this new legislation, and I would argue probably the most controversial. It is necessary because enforcement of unilateral anti-competitive conduct in the United States has significantly weakened over the past few years as a result of a number of court decisions which have narrowed the defined category of companies in a narrow range of unilateral anti-competitive conduct. An abuse of dominance provision would reinvigorate enforcement of such conduct by recognizing that a firm does not need to be in monopoly to have enough power to stifle competition, raise prices and hamper innovation, or degrade product quality. I know that it's controversial. I know that it's been implemented in Europe and not in the United States, but New York has led before. As I mentioned, New York adopted the Donnelly Act before the Sherman Act, and it's really critically important that we focus on the ever-changing environment in our marketplace. I thank you. At this point in time, I'd like to take a few questions. I'd also like to introduce, we have on the line the Deputy Chief of the Economic Bureau in the Office of Attorney General. His name is Chris D'Angelo, and he is also on the line as well.
Thank you so much, Attorney General. Before we start with questions, I just want to welcome our ranker, Jim Tedesco, to the hearing as well. Senator Gianaris, would you like to start off with questions?
Yes, thank you, Chair. Let me at first thank you, Attorney General, for all the good work you do, but especially on this issue, you and your very capable team of attorneys has been instrumental in helping us develop this and helping us kind of get through some very complicated topics. So thank you for that. I have one question about jurisdiction. We are a state, obviously, here in New York. The companies we're talking about are global in nature. And so I was hoping you could speak a little bit about the jurisdiction our state has over these companies and how we would legally be empowered to implement something like this.
As you know, the Office of Attorney General has the ability to enforce not only state law, not only the Donnelly Act, but also the Sherman Act as well. And in the past, we have brought cases against major multinational corporations, including those corporations that you speak of that are gaining dominance in the marketplace. It's really critically important that individuals understand that the tools that we currently have are not adequate to meet the ever-changing market economy. And it's really critically important that we continue to have an open market. And currently, right now, the tools are just not adequate and insufficient to deal with the types of anti-competitive conduct that we are seeing. And it's really critically important that it is our mission and our obligation and our duty to protect consumers and to ensure an open marketplace. And with increasing concentration of power, it's becoming difficult. Yes, this is a much more aggressive approach. Yes, we are modeling it after Europe's approach, But currently, there is, given the fact that the courts have narrowed our ability to address single conduct and anti-competitive conduct, it's really critically important that we have this tool in our toolkit, and recognizing that we do have jurisdiction over these multinational corporations. Many of them have not been incorporated in the state of New York, but many of them who currently do business in the state of New York, as was mentioned by Senator Ramos.
And if I could just follow up, and that last part is the critical part for me, right? It's just the fact that they engage in a significant amount of business in New York is what gives us the ability and the reach to regulate them. Is that
Correct?
yeah, great? Thank you so much.
Thank you, Madam Attorney General. I have a few questions as well. I know your time is limited. Let me just get right to it. How many antitrust cases does the Attorney General's office bring every year or investigate?
I don't have the specific number. Christy, Angela, do you have a specific number of antitrust cases that we have brought in the Office of Attorney General? During my tenure in the last year and a half, we have brought 2 cases that come to mind in particular, and they were basically cases regarding mergers. T-Mobile, as you know, was a case that we were very much involved in, but that was a merger case. In regards to an antitrust case, Chris, can you think of, can you give a number of how many cases the Office of Attorney General has been involved in and how many cases that we bring on an annual basis?
Sure. We're at any given moment, we're investigating a couple dozen matters within our antitrust bureau. In terms of actual litigation, over the course of the last 2 years, I believe we filed 2 lawsuits, the T-Mobile Sprint merger that the Attorney General mentioned, as well as we filed a lawsuit against a company called Viera, which is owned by Martin Scarelli, about conduct that was anti-competitive conduct that led to excessive pricing of particular drugs.
With the second case you just spoke about, is that still ongoing? I haven't heard much about it. Okay.
Sorry. Thank you, Chair. That case is ongoing. It's in the Southern District of New York. We've filed that lawsuit alongside the FTC, and recently were the Viera's and the individual defendants' motions to dismiss were denied by the court in that case, and so we're in the middle of discovery.
Thank you.
I guess the question, Mr. Chair, really speaks to when was the last time New York and other jurisdictions brought major antitrust cases? And the case, the most significant case is the Microsoft case. And that occurred almost, 20 years ago? And so we are handicapped, if you will, because of the limitations in the law. And that's why it's really critically important that we update our laws to reflect the 21st century, particularly given the concentration of power within tech, amongst tech companies these days that we are seeing, which I would argue is harming consumers and generally does not allow for an open marketplace.
Are you contemplating bringing any more cases this year?
Well, we have some active and open investigations which I cannot speak to, but I do contemplate initiating some actions this year.
Thank you so much, Madam Attorney General, as well as your staff for being on this call. Senator Ramos, do you have any questions?
I do. Thank you, Chair Thomas. Madam Attorney General, I wanted to ask about a standard of illegal behavior that's in the bill that speaks to companies in a dominant position. Can you tell us a little bit about what would conceptually be a company that's in a dominant position?
So I think it's important to differentiate between a monopoly and a dominant corporation. And I'd like to basically speak a little bit about the European antitrust laws, which actually focus on this abuse of dominance, which we are seeing in the markets here in the United States of America. And I think it's important to understand that there are limitations within the Donnelly Act. The abuse of dominance provision in the bill covers dominant companies, firms with a dominant position that have substantial market power. They are not monopolies. They just have substantial market power, which enables them to behave independently of their competitors and customers. It is improbable that small businesses could ever have that kind of market power. And so when we speak of dominant power, we're speaking about a limited number of individuals in the open market. And it's unlikely but and rare that we would focus on small businesses. We're primarily focusing on these companies that exercise a dominant influence in our company but are not monopolies. And in some cases, courts have held that dominant companies hold around 40% of the market power currently. And as a result of that, it's really critically important that we focus on these dominant powers that have a lot of control over pricing, over exclusionary practices, over, again, predatory acquisitions, conduct such as that we are seeking to focus on in this, in support of this particular bill and this provision.
Thank you. And I think you know probably where I'm going to go with this. I want to ask if under this legislation, then, would Amazon's domination of the supply, demand, and predatory pricing, as you speak about, would that constitute a monopoly, or would it be in a dominant position since we know it takes up so much of the market share on the internet?
And Senator Ramos, again, we would have to analyze the facts and we cannot come to any legal conclusion, but it all depends upon the facts on the ground. And clearly each and every case is different and each and every case is analyzed from that perspective based on the facts before us and the analysis of the law.
All right. Thank you, Madam Attorney General.
Thank you. Before we go to our next questions, would like to recognize Senator Kavanaugh has also joined the hearing. Senator Tedesco, do you have any questions for Madam Attorney General?
Yeah.
You're on mute. You're on mute, Senator.
Am I off?
Yes.
Hello, Attorney General, my fellow Schenectadian.
How are you?
I'm doing okay.
Good.
Hope you're doing well. And
I'm doing well. Give everyone in Schenectady my regards.
I'm going to do that. And my fellow St. Clair's citizenry really appreciates all the work you've been helping us to try to do to get down to the bottom of their concerns. We really appreciate your efforts, and hopefully at some point we could do something to help them out. But thank you so much for that also.
I appreciate that. I'm really concerned about the workers at St. Clair's. It's important that they have their pensions, and it's unfortunate that right now they are not being provided their pensions. And I know that your office, along with my office, is working to address the concerns of those workers.
Yeah, huge issue. Thanks. That's another item, though. Let me just ask you this. What do you think the immediate impact of the passage of this bill would be in the short term immediately?
Well, I do know there have been concerns, and I'm sure you'll hear from the other witnesses. They're concerned about the impact on small business. And I would argue that they should not be concerned about the impact on small business, because rarely would this apply to small business. They're going to also argue that it's vague, that the language of the abuse of a dominant company is vague, and that the bill needs to basically articulate specific conduct. And I would disagree with that. They would also argue that it would sort of impact the ability of businesses to incorporate and do business in the state of New York. And given the significance of New York and given our role in the economy, I would also reject that as well. Those are the three arguments that you will probably hear today.
Yeah. And just to follow up on the previous question about dominant position, there's a lot in this bill, but the other term they're a little bit concerned about is the term abuse.
Yeah.
As it relates to monopolistic activities. Wouldn't it be pertinent if maybe some form of definitions would be given in the bill for dominant position and the term abuse? Because obviously the concern with governmental overreach. But I think you described it pretty well when you were asked about dominant position. But you don't think it needs to have some more definition in the bill?
No, because of the changing economy, and I recognize that you're concerned about mission creep. I know that you are concerned that obviously you're concerned about the broad powers of the Attorney General, and I understand that and recognize that. And a lot of that can be addressed through rulemaking. A lot of that could be addressed in working with the legislature. I will, again, our office is in negotiations with your office. And we will work to come to some sort of common ground as long as we could enact an abuse of dominance provision that protects consumers and then focuses on the concentration of power that we're currently seeing in the marketplace. It's important that we all work together to ensure that we have an open market and that we protect small businesses and that we, again, have the tools to address the type of conduct that the anti-competitive conduct that we are seeing in the marketplace these days that so many individuals are concerned about.
Thank you so much, Attorney General. Let me know when you're coming to Schenectady. I'm going to take you to Pareca's and buy you some pizza because you know we got the best pizza at Pareca's.
I'm going to hold you to that, Senator Tedisco. I really am going to hold you. We need to work in a bipartisan way, and the best way to do that is over pizza.
You bet your life. You take care, and thank you so much for
Thank
your
you, sir.
responses.
Thank you, Madam Attorney General. Senator Kavanaugh, do you have any questions before I let the Attorney General leave for the rest of the day?
No, I think having, first, just let me say, I appreciate the Attorney General being here in person to testify in this important matter, but since I missed the main testimony, I will forego the opportunity to ask questions. But again, thank you, and I'll be reviewing the record and participating in the remainder of the hearing.
Thank you, Senator.
That being said, thank you so much, Madam Attorney General, for being with us and sharing your testimony. And thank you for everything that you do for the state in protecting us and the consumers and New Yorkers. All right. So thank you so much. Thank you to your staff for being here as well. Let's bring in the next panel. We have Kathy Wild, President and CEO of Partnership for the City of New York.
Thank you, Chairman. And thank you, Senators. Appreciate the opportunity to testify today. The 21st Century Antitrust Act would be a substantial departure from U.S. antitrust law and practice. And there, as a result, it's raised a lot of concerns across the business community in terms of what this would mean. There certainly is a case to be made, as the Attorney General has just done very effectively, that we need protections of the consumer and against and of the competitive market. But we are concerned that the proposed legislation coming at a time right now, and as we approach, hopefully post-pandemic, that the proposed legislation would not be in the best interests of an economy that's struggling to recover. The specific areas of concern, let me just elucidate. One is that the abuse of dominance standard is overbroad and could discourage could affect small, medium-sized, as well as large businesses. There's talk about the large tech companies, but there's nothing that says this wouldn't affect a large number of companies. For example, in European firms, firms with as low as 30% face liability for allegedly abusing their position. And this standard could expose almost any successful company to charges of abuse of dominance, including just offering discounted prices to consumers to gain market share. And that's a practice that's fairly universal in American business. If New York State were to adopt such a standard, it could threaten the continued growth of innovation economy jobs here with both large and small employers, and this is a tough time to be doing that. Of greater concern is that the bill would include a private right of action, which would allow individual or class actions to be brought on the basis of a standard of abusive dominance for which there's no legal precedent in the United States. This creates a new and significant level of risk that could discourage business investment in New York. Of course, businesses forced to defend against actions brought under this law would also face new cost and compliance issues that seem, again, contrary to our pandemic recovery goals. The New York Attorney General already has authority, as she described, to bring actions under Section 2 of the Sherman Act, the principal federal law under which monopolies can be challenged. While the proposed act would give more latitude, we question whether it is worth the economic damage if that could result in discouraging companies from locating operations here, especially since it's unclear exactly what conduct is meant to be made illegal under the proposed law that is not already illegal under existing federal law. So in addition, we're concerned that there would be an additional burden placed on the New York State court system at a time when our commercial courts are already overextended. It would introduce a complex legal standard, and it does not provide the kind of regulatory bureaucracy to support that the federal government has in place to enforce antitrust laws. New York State judges are also likely to be thrust into the role of being rate regulators, tasked with determining whether a firm's pricing is too high or too low. And again, these are not functions that the court is prepared to undertake. Finally, the legislation treats violations criminally rather than civilly, which would be a radical departure from current law and obviously send a chilling message to job creators. So we appreciate the thoughtful approach that the legislature has taken. We recognize the challenges and the importance of the issues that are raised by the Attorney General and by the legislation. And we welcome the opportunity to further work with the legislature to make sure that such legislation does not negatively impact New York's necessary recovery and future job creation. Thank you.
Thank you, Ms. Wild. Before we start questions, I would just like to welcome Senator Leroy Comrie to the hearing as well. Senator Gianaris, I know you have a few questions.
Thank you. Thank you, Chair, and thank you, Kathy, for joining us. And I do want to say at the outset that you and your organization have been engaged in a very productive dialogue around this bill. So I thank you for that. You've gotten us in touch with the relevant experts as we continue to think through this. As I was listening to your testimony, however, I couldn't help but wonder if this is the same arguments made 100 years ago when the antitrust laws were first enacted in this country. The laws back then were very vague by design. They were intended to be interpreted over time. They have been. And that's exactly what we're doing here. In fact, part of the problem is the courts have narrowed regulators' ability to go down this road and create good enforcement mechanisms against some of these companies. So that's what we're trying to do here. I also appreciate your defense of bureaucracy. We don't get to hear that very often. So thank you for saying that. The whole point is that we're trying to protect small and medium-sized businesses. And so that's what I want to ask you as a question is, you talked about the pandemic economy. All the companies we're talking about, the ones that are dominant in these marketplaces, are the ones that by all accounts have been doing exceedingly well during this economy. Everyone is ordering digital. Everyone's living their lives online for the last 6 months. And if you look at the profit margins of the big tech world, they're all doing extremely, extremely well. What we're trying to do is protect the small and medium-sized businesses. In fact, we're going to hear from one or two of them today who are going to speak in favor of the bill. So that's a long exposition by way of saying, do you not see a need at this point in this economy to do something like this to protect the small and medium-sized businesses against the dominant power of the big players?
Well, I think that's a fair point, and I in fact have had occasion to call the Attorney General's office in the past where we had complaints from small businesses on that very topic in the fintech area and others. So I understand that. The question that's raised, and I'm not the legal expert here, I'm relying on the opinions of others. But the question that's raised is, will this inadvertently create blurriness in the law of what constitutes a monopoly and who's abusing what, because there's just not real clarity over what this means. And if you're like a small company that's going to be a category killer entering the tech field, your desire is to, I remember when many young companies come in and they think they can dominate a field. It's a very small market. And the question is, are you trying to reach those companies that are in small markets or these really large markets? I mean, that would be one distinction that I'd say in terms of definition. If there's a startup and there's only one company in the field, they're going to have 100% for a while. Are they subject to litigation if somebody doesn't like what they're doing? So I think that's what we're looking for, is looking for clarity on these issues. And also, again, so that New York State doesn't stand out as being anti-business or anti-jobs. A lot of the jobs that are being created in New York are coming out of the tech sector. And we certainly don't want to send the message that New York is somehow taking action to go after that industry. It's our fastest growing industry in the city.
Thank you for pointing out that tech jobs are growing in New York, despite what we've heard over the last couple of years about that. And I guess what I would just say by way of closing in my time here is this is a proposal that's further being refined, and I understand your specific concern about class action as it relates to what you just talked about. We also heard the Attorney General say that she is no intention of targeting the smaller businesses that we want to continue to grow and thrive. So I think there would be some comfort in the fact that a responsible regulator wouldn't be engaging in some of the things that you're worried about while continuing to address the problems that we do have.
Agree.
Thank you for joining us again.
Thank you so much. Senator Ramos, do you have any questions?
Yes, thank you, Chair Thomas. Hi, Kathy. It's good to see you.
Hi, Senator.
Hi. So I have a few questions because I, of course, want to talk about stagnant wages. But really, there's also something to be said, I think, about stagnant entrepreneurship and stagnant creativity. Not only does the market share, of course, help so many of these corporations take over the money that is available, hoard money that from circulation, but it also hinders the ability of people like my neighbors to become entrepreneurs themselves. And so that to me, I think is a real consequence, particularly in communities of color, where we see many of these corporations come in to compete unfairly with our own vendors. And I'd like to cite as an example, right now on 82nd Street in Jackson Heights, we got our second Chipotle, and hopefully, it's going to be someday surrounded by all of the taco carts that operate and work hard in my district. So my concerns are many. And I agree with Senator Gianaris about, of course, this bill actually protecting small and medium-sized businesses. But I wanted to ask you about, the biggest corporation of them all. I have an Amazon warehouse here in my district, and the Amazon workers there are barely paid a living wage. Have experienced questionable working conditions, particularly throughout this pandemic, but before it as well. And they're continuously overworked. Not all of them receive health care. And so I'm wondering if you could share your thoughts about how their market concentration, for example, actually impacts our economy through the wages and conditions that they perpetuate. How is that helping the quality of life of the people on the ground?
Well, as you know, Amazon is a global company not based in New York, and they're not a member of the partnership. So I don't have any particular insights on that company. I'd say generally, we all understand that the concentration, the movement online has been very tough on local entrepreneurs. And that we are, in fact, engaged on a number of efforts to support and encourage the kind of local entrepreneurial activity you're talking about. So I think to the extent that you're talking about where unfair practices, monopolistic practices discourage the development of local entrepreneurship and local economies, that's something we ought to go after. I totally agree with you on that.
All right. Well, thank you, Kathy. And since I do have a little bit of time, and this is the Consumer Protection Committee, I wanted to ask then how you think these laws would improve or the opposite in terms of helping the consumer receive a better product, receive better service. how do you believe this would hinder that?
Would hinder that. I'm not sure there's a direct connection. I wouldn't know how to respond to that in terms of the law hindering consumer protection. I think the question is, how do we get the best deal for consumers, the most opportunity, the most competition among prices, and that my understanding of the objective of this legislation is to do that. That's an objective that we agree with.
All right. Well, if you agree that the consumer benefits from increased opportunity and increased competition, then what we're trying to do here with this bill is actually create an increased competition by allowing small and new businesses, medium-sized businesses to be able to compete with big corporations, and really from the consumer perspective, I believe that we would be able to better connect with local businesses, and hopefully there be more businesses and less big corporations that are hoarding opportunity, hoarding jobs, hoarding all of the money that should be circulating in our communities. Thank you.
Understood, but by necessity, this kind of bringing individual actions against individual companies is not the kind of systemic intervention that I think we'd all like to see to accomplish the goals you're talking about.
But an intervention is necessary. I mean, we can't trust corporations to do it on its own. I mean, that's what we've seen. That's what we're trying to correct. Because we can't trust corporations to do what's right by working class people.
I'm not sure who the we is.
All right, time's up. Thank you, Senator Ramos. Along those lines of that questioning, do you, Ms. Wild, fundamentally object to pursuing abuses of dominance, or is your concern limited to the concern about reaching successful small businesses that are not abusing dominance, but might somehow be pulled within the reach of the act?
It's the vagueness of the act and the definition of what abuse constitutes that concerns the experts that we've talked to.
Do you have any specifics that you can tell us right now about the definition?
I don't really, I think that's delving too deep into technicalities for me to venture on. I can certainly get you a response to that question, Chairman.
Okay. Senator Kavanaugh, do you have any questions?
No, again, I think I'll pass on this one, but thank you, Kathy.
Thank you,
Frank.
Ms. Wild, for your time this morning, and we'll go to the next witness.
Thanks for the opportunity.
Thank
Thanks,
you.
Mike.
All right, next witness we have is Luther Lowe, Senior Vice President of Public Policy for the company Yelp. I just want to welcome you, Luther, to our hearing, and you may start.
Thank you so much. My name is Luther Lowe. I'm the SVP of Public Policy of Yelp. I'm here today to voice Yelp's strong support of Senate Bill 8700. I've been with Yelp since 2008, and I was proud to be part of a small team of about a dozen people who opened our first office beyond our San Francisco headquarters in the Flatiron District of New York exactly 12 years ago today. Fast forward to today, and Yelp proudly employs over 700 people in New York. The same year Yelp was founded, a search engine called Google had its IPO after it leapfrogged services like Yahoo and AOL by taking a different approach than its predecessors. As Google co-founder Larry Page said in Google's 2004 IPO filing to the SEC, "We want you to come to Google and quickly find what you want. Then we're happy to send you to other sites. In fact, that's the point. The portal strategy tries to own all the information. Google conscientiously tries to stay away from that. We want to get you out of Google and to the right place as fast as possible." Virtually 100% of the traffic that went to google.com during this period was diffused on the web, and it oxygenated countless services. However, in 2007, beginning subtly at first, Google began seeing the web it nurtured as a threat to its existence. We know now through documents which have entered the public domain that Google was concerned with specialized search services like TripAdvisor and Yelp in particular, and executives exchange emails expressing fear that, quote, a constellation of high quality verticals like Yelp could hurt Google badly. But by this point, Google had largely vanquished any meaningful form of competition in general search. Without having to fear competition, it degraded the quality of its search and began self-dealing. Instead of sending traffic to the web, Google began exploiting consumers' trust that results on the top of the first page were always the most relevant based on hard-fought merit. In those coveted positions of the search page, it changed its designs to siphon unwitting users to its house products like Google+. Though Google has dropped the Google+ branding, the practice of steering users to its own products has only increased. Independent analysts determined that last year, for the first time, the majority of traffic going to Google either terminated on Google or was sent to secondary pages on Google. The most common consumer behavior on Google is local search, representing 46% of all search queries, or literally billions of searches in the United States every week. Today, when a mom does a search for a pediatrician in New York City on Google, instead of being matched with rich information from a New York startup like ZocDoc, which happens to have the best information in that case, that mom is misdirected to a copycat product Google hardwires to the top of its results page. Independent reporting has shown high quality information in Google's review databases is scant as they are bogged down with AstroTurf from unscrupulous business owners. In the specialized search industry Yelp operates in, the effects of Google's self-dealing are dampening to say the least. Look no further than New York startup and former local search darling Foursquare, which after rolling out desktop local search in 2010 found that Google had already salted the fields by steering most users to its own products. Without sustained growth, it eventually took a down round of funding and pivoted to selling consumer location data. I have no doubt that if Google would have obeyed the law and not engaged in monopoly maintenance, the number of local search services would be plentiful and competition on the merits would be rich. The benefactors of such competition would be consumers and Main Street small business owners. The Donnelly Act of 1899 was a critical part of the sweeping progressive era reforms that reinvigorated competition and broke the robber baron's chokehold on the market. Yet in the 21st century, we still see just a handful of companies dictating the terms of our online experiences. While the Donnelly Act was prepared to address abuses conducted between multiple companies, such as price collusion, the modern big tech giants fall outside those bounds. History has shown that antitrust laws are most likely to be enforced when state governments push for action, and the rise of big tech giants warrants a special reconsideration of how we approach unilateral monopolies. New York can serve as a model of adaptive antitrust enforcement that meets the challenges of our times and allows for true competition and innovation within the internet. I'm confident in saying, as a proud member of the New York business community, that the passage of Senate Bill 8700 will unleash competitive forces in the market, which will spur competition and produce incredible benefits to New Yorkers. I thank the committee for taking up this critical matter and for the opportunity to express our support for the legislation.
Thank you, Mr. Lowe. I would now ask Senator Gianaris to ask some questions.
Thank you, Chair. Mr. Lowe, welcome, and thank you for taking some time to be with us today on what is unquestionably an important issue. We're going to be hearing later from some umbrella trade organizations that represent tech businesses, and I suspect you may even be a member of some of them, but I don't think I'm going on a limb to say they're here not to be as supportive as you are. Can you speak a little bit as to whether, in fact, what we're going to hear from them speaks for all of the membership, or is it the case that there are many businesses probably in your situation that, and maybe not as brave as you coming forward, but who share your views and are yet still members of those groups?
Thank you, Senator, for the question. I'll just say from my own firsthand experience working at the company for 12 years and gradually learning the ropes about how a company like Yelp sort of engages with policymakers, I think early on we were really naive in joining these organizations, assuming that they had our best interests at heart. But ultimately what you find in an organization like Internet Association or TechNet is that the large players are the ones calling the shots. And so it was no surprise when I saw that TechNet had submitted a testimony against this legislation. And I think this is connected to the overall problem that these larger entities such as Google, Amazon, Facebook are able to participate in this sort of soft capture by putting forward, you know, groups that purport to represent consumers or small businesses or startups, when actually they're, you know, just sophisticated astroturfing operations, as far as I'm concerned.
Thank you for that. Interesting to note that none of the companies we're talking about today chose to be here, even though they were all invited. But they're happy to let these AstroTurf groups, as you call them, do their talking for them. We'll deal with them when they get up. Thank you for your time. So,
Thank you.
Senator Ramos, do you have any questions for Mr.
I do, kind of on a different kind of thread, if you will, indulge me for a little bit. I wanted to ask Luther more about work culture at Yelp, and how different it is, because Yelp actually has a few competitors, right? And you figure out how to capture your market share. I'm of the thinking that it allows each company within your sector to develop your own environment that better helps your workers produce creative, you know, and meaningful work for you. And if everybody just ends up working at Google someday, well, then that would hinder the creativity and the creation of new and innovative content, right, within our tech sector. Can you talk to me a little bit about, I mean, how you guys think about that at Yelp?
Sure. I think the interconnectivity between competition and work culture, it's a good question. I haven't thought about it deeply, but I'll take a stab. I think, you know, the 12 years to the day ago, I worked with that small team that I mentioned in opening New York's first office. And it was actually the same day, I believe, that Lehman Brothers collapsed. So I might be off by a day or two. But, you know, it was not exactly an ideal environment to be launching a new office, to planting a flag in the ground. But I think Yelp is characterized, and part of our company ethos is we are, you know, scrappy and tenacious despite these types of headwinds. And so I think, you know, perhaps maybe going against the question, it doesn't make life easier on our companies, on our employees, to have massive amounts of concentration in the marketplace, because we have to work that much harder. That said, we should have to work hard in some instances, because that's what competition is. You want to be able to sort of duke it out on the merits and provide the best content for consumers. So I don't know if that's the best answer to the question, and I may need to think about it more deeply, but I do accept the premise that a more pluralistic market where lots of competitors are duking it out in the marketplace and winning consumers on the merits is going to be great for workers, because those workers can compete, and if they don't like how they're being treated at one particular firm, they can go off to another.
Thank you for making a great point. Thank you, Luther.
Thank you, Senator Kavanaugh.
Thank you, Chair. So again, thank you for being here and you know, coming out. As Senator DeNaris noted, we don't always have industry participants come out in favor of these bills so forcefully. Can you talk a little bit about, you focus on Google for obvious reasons, based on your experience. Can you talk a little bit about why you think the kind of current regulatory regime isn't sufficient? Why have Google's practices not resulted in more effective enforcement action?
I see I only have 4.5 minutes to answer that question, because it requires a pretty long answer. But the long story
you want
short,
more time, but maybe the chair will indulge you. I don't get more time, but
not asking for more time. I think the long and short of it is that at the federal level, I think there is a culture of under-enforcement. The enforcement agencies have become sort of scared of their own shadows. They want the perfect is sort of the enemy of the good, and there's a fear that if they bring a case and lose, that is worse than not bringing a case at all. And so that has led, that coupled with, I think, a lot of the jurisprudence at the federal judiciary has raised the bar over and over about what constitutes, a violation of the Sherman Act. And so those two things, I think, are major components of it. And so our position on sort of the passage of new antitrust laws, both at the state and federal level, is that we believe that it can encourage more enforcement, and to the extent that regulators feel like they don't have the tools they need to bring cases, we should, especially with these modern monopolies that people kind of get sort of tripped up on, the nature of how they operate. I think it is important for the law to stay up with the times, and for enforcers to have as many tools as they feel necessary to enforce the law and rein these companies in when they're abusing their dominance. That said, I do think that it is hypothetically possible for, at least at the federal level, there's a lot of buzz right now about the DOJ alongside the attorneys general bringing a US first Microsoft style case sometime before the end of the month against Google. And that, I think, shows that, if and when we see that filing, we're going to see, I imagine, that there are enough tools there that exist. So if the laws are in place and they're not enforcing the laws, that's problematic. And so I think the addition of new laws and new tools can only encourage more enforcement.
And what do you say to this assertion, which I think we're going to hear a few times today, that it's a problem that these terms are vague, that we're not defining abuse, and we're not enumerating the various activities that would constitute abuse, and we're not giving a precise definition of dominance?
I think that that's something that needs to be hashed out in a court with a judge and an attorney. It's like it's going to be very case specific, and I don't think you want to get too prescriptive in legislation like this.
Thank you very much.
Thank you, Luther. I have one question for you. A prior speaker expressed concern that Senator Gianaris's proposed legislation could hurt small or medium-sized businesses. Do you share that concern? And if not, why not?
Well, Yelp I would define as, although I hope that everybody in New York knows and uses Yelp. Just to give you an idea, I checked the market cap just before the hearing. We're at about a $1.5 billion market cap. Google's at about 1.06 trillion. So we're 1/666th the size of Google as of this morning. And I think in my testimony, I lay out, at least in the case of local search in Google, how I think, I talk about how as a medium-sized business, Yelp and Yelp-like services, that many of which are headquartered in the state of New York, are detrimentally affected. But I think the thing that probably gets me out of bed in the morning and makes me most offended is how consumers and small businesses are affected, because consumers just pull out their smartphones and they look for something. Maybe it's low stakes like a slice of pizza, but it could be a high stakes search like a pediatrician in New York, and they are just hoping to find the best information from across the internet, because they have been habituated to expect that's what this service is providing them. But instead of being matched with that great information, they're instead being siphoned to this objectively lower quality information. And Google gets away with it because they don't have competition in the marketplace, and because thus far the antitrust laws against Google's illegal monopoly maintenance behavior have not been enforced. So it's hard to really wrap one's head around the amount of kind of deadweight loss, as the economists say, that is produced here, when you have literally billions of times in the United States a week, consumers are unwittingly mismatched with this lower quality info. When you start monkeying with the information that consumers use to decide how they're going to spend money in the offline world at that type of scale, it can really produce lots of cascading negative effects for the consumers, but also the small businesses that have, fought for these based on the merits for these for their reputations online. And I would just note there was a story in 2019 in the Wall Street Journal on how small businesses are detrimentally affected by this, in that Google Maps is really just a minefield of spam, that there's just lots and lots of misinformation. It's kind of like the YouTube problem. You hear a lot about YouTube and misinformation. On Google Maps, you've got, they open with an anecdote about a woman being ripped off by a fake locksmith in New York. And they're just, thousands and thousands, if not millions of stories like this, where that
I think we lost Luther. Luther? Okay. Thank you, Luther. Whenever you come back, just want to thank you for all the testimony and thanks for being with us this morning. We're going to go now to the next witness on our list, Jay Himes. Jay, are you on?
He's transferring now.
Okay. Good morning, Jay.
Good morning to you, Chair Thomas.
All right. I'll let you have the floor now. All right. Thank you.
Thank you very much. I appreciate the opportunity to testify in support of S87A. The views that I express are my own and not those of any association, firm, or other organization. I'll focus on the bill's provisions regarding single firm conduct and touch criminal enhancements and class actions if time allows. I'm well acquainted with competition issues in the high-tech or digital space. From 2001 through 2008, I was the chief of the Attorney General's Antitrust Bureau. I led the office's multi-year mission to oversee Microsoft's compliance with the court's decree in the monopolization case brought by New York, the U.S. Antitrust Division, and various other states. More recently, I served 4 years as a court-appointed trustee monitoring Bazaar Voice's compliance with the court's decree ordering the company to provide digital display services to Power Reviews to jumpstart Power Reviews' re-entry into the online product rating and reviews business. And in the year before the pandemic shut down travel, I spoke on competition issues in the digital world at conferences in Stockholm, Berlin, Tokyo, and even Philadelphia. I'll discuss adding an abusive dominance offense to the state's antitrust law. While not found in US law, abusive dominance is part of competition law in much of the rest of the world. An abuse offense is a powerful and flexible tool to reach single firm conduct that restricts the effective competition necessary to offer consumers products at lower prices, higher quality, and to promote greater product choice. Taking Europe as an example, abusive dominance reaches firms with a significantly lower market share than that required for monopoly power under US law. Equally important, dominant firms have a special responsibility to refrain from impairing the market's competitive structure. The abuse offense can reach conduct largely beyond US antitrust law, such as monopoly leveraging, predatory pricing, margin squeezes, exclusionary pricing strategies, even excessive pricing. Our existing antitrust tools tend to be too dull to deal with many restraints arising from business conduct in our increasingly technological and digital economy. And just sharpening the tools isn't likely to be enough. We should add to the toolbox by including abusive dominance. As proposed, the abuse offense would, in summary, make it unlawful for any person with a dominant position in the conduct of any business to abuse that dominant position. Abuse is not explained, and fine-tuning here makes sense. It would be preferable to set out categories of conduct so courts and antitrust practitioners have guideposts. In my written testimony, I discuss a few ways to do this. There will be pushback, of course, but let's not lose perspective. The offense will only reach dominant firms, and most businesses aren't so lucky to get there anyway. Will there be uncertainty in the contours of the offense? Yes, although it will diminish over time. Progressive legislation, almost by definition, introduces uncertainty. Competition itself thrives on harnessing uncertainty in innovative ways to meet customer needs and desires. So if you drill down, I think you'll find the pushback overstated. An abuse offense is not likely to be an existential threat to innovation or competition in New York. The bill's other provision on single firm conduct would prohibit monopolization. Adding this provision is unobjectionable as well. You may hear from others that including both an abuse offense and a domination offense is unnecessary. But if the objective is to better protect effective competition, innovation, and consumer interests in the business world today and looking forward, and if you believe you have to choose, I urge you to keep abusive dominance and drop monopolization. Abusive dominance can catch all the conduct that monopolization catches and more. That's what makes it a more powerful competitive tool. Furthermore, as the courts in the US have construed monopolization over the last 40 years, not much conduct gets prohibited, and that existing law would likely render the monopolization offense toothless. So I see my time is up. I am pleased to answer any of the committee members' questions.
Thank you, Jay. Senator Gianaris has a few questions.
Thank you. Welcome, Jay. Thank you for taking some time to be with us. And lucky for you, my question is right at the tail end of your comments. So I was hoping you could expound a little bit on how case law from both Sherman and Donnelly have limited the application, the ability of regulators to effectively go after some of the violations we're talking about today, thus necessitating the need for a bill like this.
Well, you have a series of decisions from the Supreme Court, and that travels down to the lower courts that construe acts of monopolization fairly narrowly. You have the refusal to deal area of monopolization law, which is a very, very narrow area to begin with. It's pretty hard to bring refusal to deal within the scope of monopolization. The Supreme Court in the Linkline case essentially eliminated price squeezes by a monopolist as a likely offense. Monopoly leveraging, which means using monopoly power in one market for a competitive advantage in another, while not expressly excluded by the Supreme Court, has suggested that it is doubtful that offense exists under U.S. antitrust law, and many lower federal courts adopt that view. There is minor dissent on that subject under leveraging. Pricing strategies often can limit the contestability of markets where you have a monopoly firm operate in multiple markets, and there's a competitor in only one, but not all of the markets. There are various bundling strategies that are difficult to challenge under monopolization law.
Thank you.
Senator Ramos. All right. Let me close this out with one of my questions then for you, Jay. The concern has been articulated that an abuse of dominant standard is too vague and will therefore be damaging to business. Can you please say more about your response to that?
Well, I think the offense is not going to reach the overwhelming majority of business, and even small internet startups with a new and different idea are unlikely to be operating in such a small slice of commerce that you could call them dominant. They will probably be borrowing on the innovation that currently exists. They will face competition from existing players who see new changes and react to them. All of that would need to be considered on the startup context. And I think that an abuse offense is not likely to be used against startups. I don't think you've seen that at all, for example, in Europe, where it's been used only companies that are legitimately dominant.
All right. Thank you, Jay, for your time. Thanks for your testimony and answering some of our questions today.
Thank you for the opportunity, Senators.
Thank you. Next up, we have Scott Galloway, marketing professor at NYU. Scott, are you on?
Great, thank you, and good morning. So thanks for having me and bringing attention to this matter. I'll make a few comments and then obviously take questions. So first off, I want to talk about, I think that the unfettered growth of these tech companies results in a lack of innovation, a lack of economic growth, and unfortunately, exceptionally negative externalities with respect to our Commonwealth. So with respect to a lack of innovation, if you look at the fastest growing parts of our economy, many of them are the sectors that these companies play in, whether it's tech hardware, search, social, e-commerce. These should be the sectors that are creating the most job growth and inspiring the most small business or new business starts, which typically create 2/3 of all new jobs, small and medium-sized businesses. But because of their dominance, what you see in these specific sectors relative to the larger economy, relative to other sectors, whether it's analytics or fintech or artificial intelligence, where there aren't dominant players, you see dramatically fewer startups. And that is, it is very difficult to get funding for an e-commerce company or a social company, a social media company, because the general consensus among investors and the mother's milk of small companies, and that is capital, is that you don't want to compete against a monopoly or a duopoly. And when you're talking about search, a $150 billion business, you have one company with 93% share. When you're talking about social, you have a $70 billion company that has 2/3 of all social market share globally under one corporate umbrella, and that's Facebook. And then you talk about e-commerce, we talk about Amazon. Amazon has between 1/3 and 50% of e-commerce, depending on how you categorize it. And immediately, Amazon will, kind of their go-to is to say, but we're only about 6 or 8% of all retail. It'd be unfair to call us monopoly. But if you were to look at traditional measures of antitrust and you look at influence and power, Amazon soaks up all the capital in the space. And that is, Amazon will lose or gain the value of the entire specialty retail, the entire department store sector. Amazon will lose or gain the value of those entire retail sectors in a given trading day. And the result is they have the ability to attract such cheap capital that for every one innovation, every one risk a traditional retailer can take, they can take 10 or 20. And if something works, they can pour so much fuel on top of it that effectively it's very difficult to catch with them. And we're not only seeing this in retail, we're seeing them go into other categories, including media, where Amazon will spend $6 or $7 billion, and the traditional players, the corporate broadcast networks, or even a company such as HBO, can't keep pace with that spend. The scale is just unparalleled. It's difficult to imagine any company, once they kind of make this jump to light speed, catching up. The result is what I would categorize as terrible incentives, or the algebra of incentive has gone haywire on us, and that is people don't typically understand the scale of these companies. So rather than comply with anti-competitive laws, rather than pay attention to teen depression, rather than pay attention to potentially your company being weaponized by bad actors and threatening the sanctity of our elections, a $5 billion fine amounts to 1% of your market capitalization for what is effectively a get out of jail free card. And I would present to most of us that if the FTC showed up and said, we're going to indemnify you against anything you have done wrong in your past up until this moment in exchange for 1% of your wealth, we would all take that trade. So the result of this scale is that the FTC is no longer, in my opinion, a regulatory body. It's become one of the best or cheapest insurance companies for these organizations. And that is the general playbook for these companies is to delay and obfuscate and then pay the fine. If you had a parking meter in front of your house that cost $100 every 15 minutes, but the parking ticket was 25 cents for violating that parking meter, you would break the law, or I think most of us would break the law, and I think that's what happens here. It feels as if government has become a co-conspirator as opposed to a countervailing force. There are now more lobbyists in Washington working just for Amazon than there are sitting U.S. senators. There are more PR executives at Facebook than there are people in the newsroom at the New York Times. And I think we're at a critical moment where if this power continues to run unchecked, we'll end up in situations where the markets are unhealthy as they are now, where just a handful of companies are responsible for 90 to 99% of the recovery in the NASDAQ. And we have this kind of K-shaped recovery, if you will, where a small group of companies are soaking up all the spoils and a small number of people are soaking up the spoils, leaving all other companies and all other cohorts with essentially the crumbs to feed off of. And I think the net of this is we have a very unhealthy economy where we continue to aggregate more and more of the spoils to fewer and fewer players. And finally, I think we need to look at antitrust not as a punishment, but as a liberation, that these companies are not necessarily run by bad people, but we have a proud history of antitrust that helps oxygenate the marketplace. And typically when you break these companies up, everyone benefits, including the shareholders of the companies that have been broken up. So I don't think of this as a punishment, but simply oxygenation of the marketplace and the economy.
Thank you, Scott. Senator Gianaris?
Thank you. Professor, thanks for joining us today. It's good to see you, even if only virtually. My experience is those that have power and those that have wealth are very reluctant to give it up. And so we're hearing a lot of criticism of this proposal that, you know, the sky will fall if we pass it, the economy will collapse, et cetera. Yet Europe has a very big economy. These companies are global. They have been much more aggressive in their antitrust enforcement, or their version of it anyway. I was hoping you could speak a little bit to some of the actions taken in Europe and how they haven't hindered the growth and innovation of these companies even one bit.
Well, if you look at the underlying, so Europe has been more aggressive around regulation. And if you look at why, if you think about it, they get all of the downside. They get the weaponization of their elections, they get depressed youth, they get job destruction, they get anti-competitive behavior, but they get very little of the upside. There are very few hospital wings or university buildings named after Google or Facebook billionaires in Europe. And this is kind of stiff in the backbone of European regulators. And it doesn't seem, as a matter of fact, unfortunately, some of the regulation in Europe, you would argue, has errantly benefited the incumbents. And that is, Facebook has the thousands of lawyers and the billions of dollars to comply with the gymnastics required around GDPR, but some of the small and medium-sized media companies are struggling to comply. And whereas a consumer may have to press, yes, I accept the following cookies or what have you, because you have Google, which is a monopoly, and consumers have a difficult time giving up that monopoly, a smaller media company may not have the same receptivity from consumers to default and agree to give up their information. So I think in the instance of European regulation, I'm not sure it unwittingly hasn't actually entrenched the incumbents. But typically, this type of, I won't speak to regulation because I don't feel as if I have a lot of domain expertise. But, and I know you have Professor Wu on here who is going to forget more about this than I'm ever going to know. But generally speaking, when you look through history in Europe and the US, when companies are broken up, it unleashes tremendous shareholder value. If you think about the breakup of the AT&T into the Baby Bells, I think all but one of those companies ended up being worth more than the original AT&T. And we had data, we had fiber, we had optics, we had no idea that these things were lying dormant in Bell Labs. And right now, when you have YouTube and Google under the same roof, they're coordinating as opposed to competing. And you would argue there's been a lack of innovation specifically around putting in place protections such that, for example, young men aren't radicalized. But I don't see any, Amazon's growth is stronger in Europe than it is in the US. Google and Facebook aren't saying in their earnings report that they've registered any damage or lack of growth because of a European slowdown due to regulation or antitrust threats. So to your point, there's no evidence that this additional regulation has in any way hamstrung them. And I fear it's actually done the opposite, that it's actually ended up helping entrench them.
Thank you. And pivoting a little bit to a somewhat different question. If I'm not mistaken, before you became an academic, you were in this world yourself. And my question is, has the market concentrated dramatically since that time, or were you seeing some of this yourself, even back when you were kind of in the industry?
So I was in e-commerce in the very early days in the 90s in San Francisco and ran an e-commerce company. And just over the course of, say, from 1997 to 2003, you saw certain keywords go from 10 or 20 cents to $2 or $3. So prices skyrocketed. But what you also saw was Amazon come in, and Amazon is now the largest consumer or the largest customer of Google and has the capital to essentially outbid anybody. And what you've seen slowly but surely is a sequestering of all consumer traffic on the internet to one of a small number of players. That whether it's through Amazon, which is now the second largest search engine in the world, or them dominating keyword bidding, or it's Facebook that now is responsible for more time on their properties than the entire television landscape combined. You have a small number of players, if you will, that have grabbed a disproportionate amount of the attention economy. So as a result, almost no startup, and oftentimes a lot of legacy companies, which tend to be better employers and better taxpayers, have been denied of the oxygen of attention. And that is the medium that is growing the fastest is obviously the online medium. And increasingly every day, we see a small number of players grab more and more share, and the oxygen is slowly leaving the room for everybody else.
Thank you so much.
Thank you, Scott. Senator Ramos, do you have any questions?
Yeah, thank you, Chair Thomas. Hi, Scott. How are you? Thank you for joining us. I wanted to ask probably a few more bird's eye view questions, just based on your expertise in talking about how these anti-competitive practices have actually exacerbated wealth inequality overall, whether it's the stagnation of entrepreneurship or the stagnation of real wages for workers. And perhaps what your opinion is, if you could expound on that, and then perhaps what your opinion is in terms of figuring out how it is that we can find seed money, if you will, to help generate more creativity, which of course is good for humankind, I believe, in general, but also how we can help those who are excluded from so many of these opportunities, as particularly as workers. Can you talk about how the connection with overall income inequality, especially given that New York is the state where income inequality is greatest in our country, unfortunately?
Sure. I think that the concentration of wealth across a smaller and smaller number of companies is absolutely an accelerant for income inequality. And if you think about, let's look at Uber, the ride-hailing business is becoming a duopoly. The average wage at General Motors and Ford is $27 plus health insurance, plus benefits. And Uber, the average wage is, by some standards, less than minimum wage. By some studies, 12 to 15 bucks an hour, and there are no benefits. And you have 4 million drivers, all of whom, or none of whom, have any sort of minimum wage protection or benefits. So slowly but surely, Uber, with only about 22,000 employees, garners the market capitalization that's greater than those companies. And so the question is, what kind of world do we want to live in? Do we want to live in a world where transportation companies employ hundreds of thousands of people at 27 bucks? Or do we want a world where we have a small company with only 22,000 employees that figures out a way to deploy software across 4 million partners, which is Latin for people who have no minimum wage protection. I would argue no dignity of work. And people say, well, where does all that value go? If you can arbitrage people by using software and taking advantage of their need for flexibility to lower wages, where does all that value go? It primarily goes to the shareholders. And when 10% of US households own 90% of shares, what we end up with is this upward cycle. If you're in the shareholder class, you end up doing very, very well. It's great to be a shareholder of Facebook, Apple, Amazon, or Google. And the result is more and more returns to the shareholders. We have kind of made a conscious decision with a lack of antitrust, with our tax policy, where we pay less taxes on the capital that money makes. And the conscious decision is the following, and that is if you bucket our society generally into 3 cohorts, whether it's the consumer, the shareholder, or the worker, we've decided that the consumer comes first. That's the test for everything. Is it less expensive or better for the consumer? 2 shareholders, and a distant third is workers. And I think a lot of the reason we're having these discussions right now is, have we got that wrong? And by the way, people will always point to the consumer test, that our prices have stayed low. I would argue that as consumers, our prices have skyrocketed at the hands of these monopolies. If you're a parent, what is the cost you're paying for addiction to platforms? What is the cost you're paying to social media properties that aren't concerned about your daughter's increasing tendencies toward depression? If you're Facebook, what is the price we incur when we have a 60% increase in teen suicide? What is the price we incur when our elections are no longer seen as having the integrity they used to? I would argue that as parents, as small business people, as citizens, our prices have absolutely skyrocketed at the hands of these organizations. It's just that they're non-economic prices. And the wheel spins. Every year, more and more gains to a smaller group of companies, the shareholder class, who also pay lower taxes. And we've seen companies ranging from Microsoft to Apple trade from a PE of 7 and 12 respectively to 40 and 29. So effectively, everyone's just throwing in the towel and buying one of a small number of companies, which creates capital markets that aren't functioning, where again, more and more spoils go to fewer and fewer consumers. So I think antitrust and tech monopolization, if you will, is at the heart or one of the key contributors to income inequality. And then I think we would have a lot more innovation, a lot more creativity if we force these companies to be broken up. I think it would inspire a wave of new startups. Some would win, some would fail, but I think you'd see a great deal more innovation.
All right. Well, thank you, Scott. And I think I'm pretty much done with my time. Yep, time's up. But I'd love to connect on a few other ideas that we've been working on. And Chair Thomas, I want to thank you for holding this hearing. I want to thank Senator Gianaris for your bill. I'm going to have to sign off and continue with my day. But thank you so much. This has been a really important and insightful hearing. Thank you.
Thank you, Senator Ramos, for being on. Before I close this down, I have a few questions for Scott. You suggested that Senator Gianaris's legislation could lead to pro-shareholder oxygenation of the market. Do you have any thoughts on why some large corporations might not be seeing things the same way that you are in this regard?
Almost all of these companies have a two-class shareholder system, and that is they have disconnected accountability and ownership with authority. And that is typically the reason we call it equity. Is that you are supposed to have an equal say in the direction and decisions of the company. The corporate governance is largely based on our governance, and that is it's supposed to be kind of one person, one vote, one share, one vote. But each of these companies, because they were so exciting to investors, were able to get through dual-class shareholder systems where a small number of people who own a minority position effectively control the company. And if you think about all of the stakeholders, the shareholders, the employees, the Commonwealth, the tax base, everyone typically post-breakup, and almost every empirical study done on breaking up companies benefits. Shareholders do well. Job growth happens. Broader tax base. The one stakeholder that doesn't do well in a breakup is the CEO, who wants to be the king or queen of all of Westeros instead of one of the 7 realms. And unfortunately, that's usually the person that gets to make the decision because of these dual class shareholder companies. So I think the majority of economists and shareholders would say a broken up Amazon would be potentially good for shareholders. I think AWS would be the most valuable company within a couple of years of the spin. It's hard to imagine that Facebook wouldn't decrease or stave off the scrutiny, and potentially Instagram would be a juggernaut on its own. It would solve a lot of problems if this company got broken up. But basically, you have a 34-year-old who's or a 36-year-old, I apologize, I forget how old Mr. Zuckerberg is, who's a college dropout, whose first professional endeavor was a website evaluating women on their physical appearance, who gets to decide the algorithms that largely dictate the content spread to a population greater than the Southern Hemisphere plus India, and he can't be removed from office for probably 50 or 60 years. So I would argue that one of the absolutes here is that power corrupts, and that the power we have let accrete to not only a small number of companies, but a small number of individuals is not only a threat to our economy, it's not only a threat to shareholders, it's a threat to our society. That history shows us that when you put the media, this type of media, in the hands of so few people, it can lead to very, very ugly places. So back to your question, why are they against it? I'm not even sure the company's against it. I'm not even sure the shareholders are against it. But the person who owns those all-important voting shares typically likes sitting on top of the Iron Throne and is very reticent to give it up.
Thank you, Scott, for your time today. I'm going to invite the next witness to come on. We have Professor Tim Wu at Columbia Law School.
Hi there, how's it going?
Good morning, Professor.
How are you all?
Good, good. Whenever you're ready.
Okay, sure, I'll take the first 5 minutes here for a few comments. Let me just say first a little bit about my background. I'm a professor at Columbia where I teach antitrust. But my background relevant to this is I worked in antitrust enforcement both at the federal government in the FTC and at the New York AG's office in the Antitrust Bureau. And so I have some perspective. I feel like I've been a party to the effort to revive antitrust law and have seen some of the challenges. And for that reason, I feel strongly that New York should pass this law and restore or put New York in a position of leadership in this country. I have the belief, and I think this is something a lot of New Yorkers feel, that when the federal government lets us down, that it's necessary for states like New York to fill in the gaps. And indeed, that's what we've been trying to do since I think over the last almost decade of antitrust enforcement at the New York AG's office. But the state has been thwarted in several ways that I think passing this law would improve. Now, I want to say at the outset that despite the focus in this hearing on the tech industry, and I don't deny that tech is an important target, I want to make it clear or remind us that some of the most important impacts would be outside of tech industry. New York has been a leader in enforcement against pharma, for example. New York brought a very important case 2014 against the patent hopping practices. New York has also been a leader in enforcement against telecom practices in the effort to stop the Sprint T-Mobile merger, most obviously. So I just want to make clear this is not only a tech-specific law, and there is a lot of important stuff that happens outside of tech. Let me make my broadest point. I see over the last 40 years that the United States has been experimenting with weak antitrust laws based on the theory largely derived from microeconomic principles from the Chicago School that it would be better to do so. And I think the results have been clear. Lack of antitrust enforcement, I think, has led to a highly concentrated economy that has created enormous disparities in wealth and income. We have not seen, as Scott Galloway was saying, the reduction of prices that would have promised. We have not seen the certainty that was promised. Instead, what we have is an economically divided nation where people concerned about their well-being. They feel that it's a rigged game. And I think that has also contributed to a politics of extremism, nationalism, blaming scapegoats, immigrants, China, you name it. It's a bad, and I don't want to say antitrust is the only cure, but it is the traditional remedy for this kind of problem, and one we've given up on for the last 20 years or so. So let me make 3 specific points about this law that I think are important and why I think it's important. One reason is that the federal judiciary has proved itself very hostile to all but the most perfect antitrust claims. The best evidence of this was the Sprint T-Mobile case. The New York and California put on a very strong case, showed convincingly with the best witnesses that that this was going to cost consumers millions, if not billions of dollars. Still, a federal judge wasn't willing to stop that merger. So, if the federal judiciary is not going to accept good antitrust cases, you need to do something different. Second, I want to say the abuse of dominance standard does fill a very important loophole in the monopoly requirement of Section 2. This gets technical, but in enforcement, we constantly found that we had large dominant entities, like Amazon being an example, or maybe Apple, who are not technically monopolies, even though they're obviously dominant firms. And even faced with the most egregious abuses of their power, there was nothing you can do. So that's an important loophole to be filled. The last thing I'll say, this is my only questioning. I think it's worth questioning whether, however, there should be a private right of action. Maybe this reflects my view as a government enforcer, but particularly the abuse of dominance standard. To the degree there's concern about uncertainty, I think the best answer would be to have the AG enforce that provision and not have it be a private right of action. And that should alleviate some of the concerns that the law is too vague, alleviate some of the concerns that it would become kind of a feeding fest on New York business. All right, that's all my time. Thank you again for inviting me here.
Thank you, Professor. Senator Gianaris has a few questions.
Thank you, Professor. Thanks for joining us. Thanks for your great work over the years on this issue. It's been educational even before we met to learn about antitrust law with you. I guess my question is, especially as the federal government is considering pursuing an action against Google, from what we're seeing reported. You've done some work about whether or not financial considerations are the only possible concern for consumers as it relates to antitrust damage to a consumer. Can you speak a little bit about non-financial, non-price related concerns that may also impact consumers, whether it be quality of product or what have you?
Yeah, I think that the obsession, sort of laser-like obsession on prices is whether the only thing that matters to anybody is whether or not you pay 50 cents more for, I don't know what. I think that it has been misguided. I think there are a lot of harms that people feel in reference, in particular, to the Google case or some of the tech environment. You have, concerns about privacy. I think Scott Galloway outlined some of the other concerns. You have a question of whether attention is being stolen, whether there's damage to our political system. These are the kind of harms that I think are not well reduced to just a single consumer price. I also want to say that antitrust has lost its traditional emphasis on the concerns of workers. The law was passed, the federal laws and the New York law were passed with concerns about the conditions of work, and that is something I think has been absolutely lost. And it doesn't take a genius to realize that if you have a sector dominated by just 2 or 3 companies, maybe a few, think about hospitals in this state, for example, where you've had hospital mergers, where you have just reduced it to a tiny handful of hospitals, in some cities or some towns just one hospital. Well, what's the bargaining position of a nurse like in that situation? If you say, hey, I'd like a raise, they're like, well, what are you going to do? So I think one of the reasons for long-term wage suppression is over-concentrated industries. And I think that can get lost sometimes in our discussion of some of the other things, but I think we need to be really serious about the effects on labor, effects on workers.
And to what extent is that currently considered under existing laws?
Barely, weekly. This was, no one has brought cases to deal with this. And one of the ways you need to deal with it is by blocking mergers, for example, like blocking hospital mergers that are going to create these impossible situations for workers. But it all comes down to, can we prove enough evidence that the price will go up $1 or something like that? And even when you prove that, you still lose in federal court. So, if I were going to add something to this law, it would be, if I were going to add, and this is a little ad-libbed, merger control is a major, major problem for the federal government. And the federal judiciary has been willing to approve almost everything, same with the federal government. And I think that's one of the things that's been very hard on workers.
Thank you.
Thank you, Professor. I have a few questions here for you. We have heard repeatedly from independent pharmacies that pharmacy benefit managers, PBMs, seem to exercise power that raises anti-competitive concerns. Independent pharmacies are going out of business while PBMs are making profits and prescription drug prices are escalating. Do you have a view on whether Senator Gianaris's legislation could help in that arena?
Yes, I do. And I think that's a great example of something that has totally fallen through the cracks. I've been watching that situation. I mean, the pharma industry is just a nightmare of everything that's possibly wrong. I don't know how I got into this, but I was looking into rabies shots the other day. And, in India, they're like $6, actually, because my wife was bitten by a dog. To make it dramatic, it's $6 for the dose. In the United States, people are regularly charged over $10,000. One person was billed $43,000. It was in Florida. But anyway, that's an example. The situation you described, I've heard so many complaints about that. And it's one of these situations, federal government hasn't done anything, probably because, it's not clear they have a monopoly. I'll just be like a lawyer. We don't have proof of an agreement. That's why you need something like an abuse of dominance provision to go after this kind of stuff, where everybody knows that something is wrong here. And the fate of independent pharmacy is very similar to a lot of independent businesses, where there's a core group of middlemen who really are exploiting their position. It's same in agriculture, in upstate agriculture, where you just have a tiny number of middlemen who have seized the power in this economy and have squeezed everybody out of it and taken all the profits for themselves. So this, I believe, passage of this law would be one of the opening salvos in an effort to change this economy and make it work again for independent business, for small business, for people who, really treasure the economic freedoms that used to be what this country was about and what the state was about.
Thank you. Next question that I have is, if we limit the abuse of dominance standard to AG enforcement only, doesn't that take away the very important enforcement mechanism of private lawsuits? Meaning, haven't we seen situations where the government has failed to bring needed enforcement action and private lawsuits have actually brought more important results that benefit the public as a whole?
That has happened. I won't deny that, particularly under the Clayton Act and the Sherman Act, federal laws. But I'm suggesting that if the concern is, and I guess this is if the concern is that these laws will be too stifling, the abuse of dominance standard, if it becomes something that attracts a huge amount of plaintiff activity against maybe not actually dominant, but mid-sized firms, and leads to a lot of settlement. The question is whether the cost of that might outweigh the benefits. I mean, I take the point. I think that's true, that sometimes the AG's office might not do stuff. They also have resource constraints. But, I think that having worked in federal enforcement and state enforcement, we spend a lot of time thinking about whether we should bring a case. And we do so when we think not that we can make money off the case, or there's a lot of damages. I mean, the AG's office doesn't really care about damages. It cares about whether this would be good for restarting this area of the economy. And I'm nervous that the incentives of private lawyers have more to do with whether this case is a payoff or not. So that if you wanted one way, one means of trying to dampen the concerns that this is too much deterrent, that would be a way to do it.
Thank you, Professor, for answering those questions. Next, I have Senator Kavanaugh with a few questions.
Thank you, Chair, and thank you, Professor Wu. I want to follow up a little bit more on this question of limiting the private right of action. You're suggesting that we would limit enforcement to the AG or other government entities, specifically for the abuse of dominance provisions, or
right.
Would you? Because I guess there was previously an ability to bring private right of actions under some of the other provisions of existing law, and perhaps and this bill would reassert that for various provisions of law. Would you suggest that there be a private right of action, but it be restricted such that it's not available for abuse of dominance, or are you suggesting we drop the private right of action entirely?
I'm not suggesting the private right of action entirely. I'm suggesting it for the abuse of dominance. And that's because as some of, this is my view as a professor as much as an advocate, I just think that the concerns are the strongest when it comes to a completely a new standard, which I think is a very important one. I think it fills a lot of loopholes. I'm slightly reminded, this gets technical, of the Section 5 of the FTC Act, which has not necessarily been successful, but one of the ideas of its usage is that, the government, state and federal, are very careful about the suits they bring, and their incentives are different. As for, right of actions generally, they can already bring those kind of cases under the Clayton Act anyways, so there already are private lawsuits.
Right.
Damages.
And can you talk a little bit about that? The bill provides for civil penalties and remedies as well as criminal penalties. Can you talk about the sort of relative value of those in, creating the benefits, the public benefits that we're seeking here?
Yeah. So someone had said this was a radical departure. I think it was this is not a radical departure. Sherman Act is a criminal statute. That seems to have been forgotten. It is a tradition in the antitrust laws to have a criminal component for the most egregious, knowingly malicious actions undertaken, usually price fixing. And actually at times in history it has been enforced against other. I think it's important to have that there to let business know government is serious, and know that if you know what the law is and you maliciously, deliberately violate it, that there has to be the possibility of criminal penalties. In the old days, in the 30s, they'd actually bring in the CEOs and fingerprint them and mugshot them. And I think, if you want to talk about real deterrence, as opposed to, pay some lawyers to get rid of this, if you have evidence people are knowingly breaking the law, why should you be above the law? And I think today's CEOs are far too insulated from any sort of possibility of personal, suffering something personal. So that's why I favor keeping the criminal side in there.
Great. And so I appreciate your emphasis that this kind of statute would affect all different areas of our economy, not just the tech sector. But obviously a lot of your work has been in the tech sector, particularly in the areas of privacy and kind of, the word abuse came to mind, so I'll use it, even though it has I guess it's a term of art in this bill. But just can you talk a little bit about how this might, how the abuse of dominance might help with, people's growing concern that their privacy is violated, that their commercial choices are restricted, and all the sort of downside.
Sure. I'll give an example. I know, I'm not in government, so I can name parties. If you take a company like Facebook, so they achieved a dominant position in social networking by the 2010s. And the way they, the means in which they harm consumers was abandoning their privacy protections, which they had promised people, because they'd achieved dominance, had no competition. So that is a lot easier to understand with this abuse of dominance standard, this sort of consumer harms through stripping privacy protections, lying about them, giving people fake buttons which are supposed to protect their privacy and didn't. That kind of stuff. We in the federal government and state, we felt fairly powerless to do anything about that using the Sherman Act. But with an abuse of dominance, it's like a knowing use of your dominance to abuse consumers and break promises. I think it fits a lot better. I see my time is up, but I think it would really help.
But just if I may finish out with the indulgence of the chair. So you're suggesting that you could identify that harm, the abandonment of privacy, as an abuse of power, and if the government were able to abuse of dominance rather, and if the government could sort of kind of categorically conclude that that's harmful to consumers of the product, and that the company wouldn't be able to get away with it without having the dominance that they have.
Right. I think there's a lot more room for that as a category of harm. For privacy harms to be considered a category of harm.
So you wouldn't need to, for example, demonstrate that if there were, that some other company is trying to protect people's privacy, but is unable to because of Facebook, you essentially identify the harm and persuade the courts that that's the harm within the scope of the statute.
I mean, if I were bringing the case, I would bring other sources of harm too, like raise prices to advertisers. But I think that the abuse of dominance, this idea of abuse, includes the kind of non-economic, non-consumer price harms that are so important and are what we see in today's economy.
Great. Okay. I appreciate it. And thank you, Chair, for indulging a few more minutes there.
Thank you, Professor, for answering our questions and for being with us this morning. I'm going to let you go, and I'll bring in the next witness that we have, Matt Stoller with the American Economic Liberties Project.
Hi, am I on?
Yes, you are. We just cannot see you.
Okay, great.
Oh, there you are.
There we go. Okay.
Whenever you're ready, go ahead.
So thank you for having me. My name is Matt Stoller, and I am the research director of the American Economic Liberties Project and the author of the book Goliath, the 100-Year War Between Monopoly Power and Democracy. We desperately need stronger anti-monopoly laws, such as the 21st Century Antitrust Act. First, well, I want to acknowledge that Amazon, Google, and Facebook are some of the most dangerous concentrations of power in America because they can control and manipulate the flow of information. But it's important to recognize that because of our weak antitrust laws, monopolies are actually everywhere, and these corporations are simply the pace setters in a monopoly-dominated economy. So here's a story that makes the point. We all know about Martin Shkreli. In 2015, Shkreli became notorious for buying the license to make an off-patent drug, Daraprim, used by HIV/AIDS patients. And because he had a monopoly, he raised the price from $13.50 a pill to $750 a pill. And in 2017, he went to jail for securities fraud. Today, the New York Attorney General and the Federal Trade Commission, among others, are suing him. Now, you would think this is a story of justice, but here's the thing. It is 2020, 5 years later, and the price of a Daraprim pill is still $750 because he still retains his monopoly. In 1938, New Yorker Franklin Delano Roosevelt gave a speech on curbing the power of monopolies. The liberty of a democracy is not safe if the people tolerate the growth of private power to a point where it becomes stronger than the democratic state itself. Today, our democratic state is so feeble that not only can we not address our anti-competitive practices by trillion-dollar technology platforms, but we cannot even stop a cartoonish jailed sociopath from harboring HIV/AIDS patients for money. Because our legal framework is set up this way, and because monopolies are so profitable, there are Martin Shkrelis everywhere in every corner of our economy. In other words, powerful new tools against monopolies like this bill are desperately needed. America used to have stringent rules against monopolies. Prior to the 1970s, the story of Martin Shkreli, or Mark Zuckerberg for that matter, would have been fiction, and probably not even that, because it would have been so unbelievable. But in the 1970s, a scholar named Robert Bork changed our understanding of what anti-monopoly laws are about. He successfully argued that efficiency, not competition, was the purpose of the law. While the Sherman Act stood, enforcers in courts began to interpret it in ways favorable to monopolists. Consolidation in every industry is the result, with big tech as the pace setters of a new monopoly-dominated economy. Now, over the last 2 decades, 75% of US industries have consolidated. In big markets we know of, like search engines and airlines, but it's happened in small markets as well: syringes, portable toilets, even cheerleading. Enforcers have also become meek. At the federal level, the Department of Justice under Bush, Obama, and Trump didn't bring a single meaningful monopolization claim. And yet it's not all on the enforcers, who often feel they must meet unreasonable standards. They have to show that a company is a monopoly, that it's unfairly using its position to maintain its monopoly with anti-competitive conduct. To draw an analogy, it's as if to prove a current monopolization case, you have to show that not only is the mob boss stealing from people in the neighborhood, but also that he's the only mob boss stealing in the neighborhood and that he is burning down the offices of his competitors. It's a much higher burden of proof and beside the point. Now, there have been some victories, but unfortunately we have, as FDR put it, tolerated the growth of private power to a point where it has become stronger than the democratic state itself. To maybe update his quote a little bit, we've allowed the Federal Election Commission to be made irrelevant in favor of the Facebook Election Commission. This bill is designed to address the crisis of monopoly. It tightens standards around the abuse of corporate power. Behaviors that are difficult to tackle under current case law might be reachable through an abuse of dominant standard, include self-preferencing, predatory pricing, leveraging dominance from one market to another, exclusionary conduct, refusals to deal, and so on and so forth. This bill also authorizes class action lawsuits, and it increases criminal penalties for monopolization. Most importantly, it's a statement that New York rejects the federal case law limiting antitrust enforcement and expects action against monopolies. It could be clarified with the statement that existing Sherman Act precedent doesn't apply to this bill. To give guidance to judges, legislators could define what constitutes an abuse through statutory language or delegation of regulatory authority, or both. I would also encourage more assertive authority to block mergers. Regardless, the bill is important, and it's a model for other states and for Congress to follow. And you should ask anyone opposing this bill to explain why we should prioritize Martin Shkreli's right to control people's health. Ask them to stop hiding behind words like unintended consequences or fake, overbroad interpretations of what this bill would do, and ask them why they support the ability of Martin Shkreli to continue to extort sick people from jail, because that's what the stakes really are. Thank you.
Thank you, Matt. Senator Gianaris, do you have any questions?
Yeah. Hey, Matt. Thanks for joining us. Could you speak just for a little bit about? I asked this question to one of the earlier witnesses. In Europe, they have an abuse of dominance standard, as many other countries around the world do, and yet they don't seem to be suffering from lack of innovation or stifling the economic growth that this industry brings to bear. So why is it that the sky would fall in the US if we did this, but it's not falling anywhere else?
Well, I mean, it's just not true that more assertive antitrust rules would hinder competition. In fact, the biggest problem that small businesses tend to face, and medium-sized businesses at this point, even large ones, is that you have a private government in the form of monopolies that are over-regulating those markets. I mean, I hear from small businesses all the time, independent pharmacists, for example, that Senator Thomas brought up, or cheerleading gyms, or people that are experimenting in pharmaceutical middleman space. They're hindered by monopolists, by gatekeepers. And what this bill really would do is it would blow up those gatekeepers and allow for commerce to actually happen. And where you do see more aggressive antitrust enforcement, whether that's in Europe or whether you go back in American history, just to the Microsoft case, what you see is more competition, more innovation, higher wages, more jobs, so on and so forth.
Great. Thanks so much, Matt.
Thank you, Matt. I have a question from your opening statement. You talked about Martin Shkreli,
right,
and how he abused the system and how it's still in effect. How can you change that? And will Senator Gianaris's bill be able to protect consumers from that kind of monopoly?
Yeah, so it's important to recognize that what Martin Shkreli is doing, it's very common, which is, he has this monopoly on Daraprim, which is not a patented drug. And what he did is he tied up the distribution of that class of medication with contracts with distributors, and he made sure that he had control over the key source of chemicals for that drug. So then he could deny them to potential competitors, and he also didn't let them have access to data or access to the Daraprim drug. All of these things would be an abuse of dominance. And the Attorney General has brought a monopolization claim. But this should never have been a case. I mean, this is just outrageous. It's been 5 years. If we had a clear abuse of dominance standard, he would not have been able to do this in the first place. So that's how the bill would have addressed it. I mean, it also increases criminal penalties, and he's already in jail. It's pretty evident that he knew what he was doing. He knew what he was violating the law. He has violated the law in the past. So there would also be the potential for increased criminal sanctions there.
Thank you, Matt. We will go to our next witness now from the Business Council, Ken Poklasky, the Vice President, and Lev Ginsberg, Senior Director of Government Affairs. Welcome, Ken and Lev. And both of them be unmuted, please.
Thanks to
Thank you.
Chairman Thomas and to Senator Gianaris for having us today. I think it's fair to say we, as a statewide lobby organization, have spent less time on the issue of antitrust legislation than many of the witnesses today. But the bill we're talking about today, Senate 8700, certainly has gotten the attention of our members. And we've heard a significant amount of concern. I just want to hit several of those highlights. I think it's important to recognize that, as an organization, our membership are committed to supporting competition and the just, effective enforcement of antitrust laws. But we do have some significant concerns about this bill. And that while several commentators today have pointed out, the bill's focus is clearly on the technology sector. Its provisions are certainly not limited to any specific category of business, or for that matter, any specific size of business. In fact, we've heard concerns from a wide range of industry sectors, including tech and telecommunications, but also pharmaceutical, financial services, manufacturing, and others. Our prime concerns about the bill include the following. Some of these have been talked about earlier. It significantly increases criminal penalties for business practices that are currently not criminal under federal law, nor the laws of other states, while at the same time creating significant uncertainty by providing no criteria, parameters, or limitations of what business activities constitute an abuse of a market position. Second, this undefined standards will open the door to the Attorney General and perhaps future Attorney Generals and private litigants to challenge a wide range of business practices that, in fact, do benefit consumers. Since the newly proposed abuse provisions in this bill seem to fail to consider actual harm to consumers with regard to price, output, quality of goods, or other purposes. Interestingly, the prior witness made the comment, if you know what the law is, and I believe you said, you didn't say intentionally, but you willfully violate that known law, there should be significant criminal enforcement. And we would argue a business would not know what the law is, massively, broad, undefined terms here as to what, constitutes an abuse of power. The ability for either an AG or a private litigant to define the share of the market being abused as broadly or as narrowly as it fits their immediate purpose makes the parameters of this bill, certainly unknown. So this vague abusive dominant position provides could provide a chilling effect on common business activities that provide substantial benefits to consumers. I know while pharma and small businesses have been talked about a bit, consider just one example where a small emerging biopharmaceutical firm with a breakthrough treatment, and a third party could claim that the firm has both the dominant market position, is both the specific market and the share of the market that constitutes dominance can be defined by the plaintiff, and is abusing that power through its current pricing practices. Again, with the abuse concept being left to be defined by the plaintiff. That's just one example. We're talking to our members about other specific examples, and they're out there. And granted, this Attorney General may wield this significantly broader enforcement tool very wisely. but there's nothing in the bill that would limit the authority of future attorney generals or private litigants to narrowly define, markets and go after activities that, we would believe are and should be fully lawful. And finally, as been talked about, antitrust laws historically have focused on consumer welfare and protecting competitive process and not individual competitors. And some of the questions and comments by members of the Consumer Protection Committee today, suggest visions of a far broader application of this bill than perhaps the sponsor has. One comment was that this legislation is all about protecting small and mid-sized businesses. And it's a direct quote from one of the other panelists. And finally, the significantly enhanced criminal provisions and the potential for class action claims by private litigants will apply tremendously increased leverage against a business who believes its business practices are recognized as legal in New York and most other jurisdictions. Our concern is that the real effect of this bill is that it's going to produce a significant tipping of the scales, if you will, in antitrust enforcement in favor of the state, and to bring significantly increased leverage against targets of antitrust actions. As always, we appreciate the opportunity. That's an overview of our concerns, and we welcome the chance to answer your questions today and to continue the conversation after this hearing, including engaging some of our additional members in the conversation. Again, thanks for the opportunity.
Thank you, Ken. Does Mr. Ginsburg have an opening statement as well?
No, Lev's here to help deal with Q&A.
Okay, you guys are just going to tag team. All right, fine. Senator Gianaris, do you have any questions?
Offering it, but that didn't seem to be the
Yeah, Ken and Lev, thank you for joining us. So part of the exercise, which is why we're having this hearing, is because this is still a proposal that's being refined, and we want to hear what the concerns are. And so as I hear you talking primarily about the lack of specific definition, would it give you more comfort if ultimately there was some rulemaking associated with it that would require some definition to give the operators in these industries more certainty as to what they're expected to do and how they're expected to operate?
It's an interesting question. I if I had one moment. Thanks, Senator. I think that it's a sword that sort of cuts both ways, right? I mean, it would depend on what that would look like. We have 100 years of case law on both federal and state antitrust law, which we've grown to depend on. I certainly heard your opening statements and appreciate the things that you said about, obviously, the world has changed, technology changes, business changes, all of these things. But I think that with 100 years of case law, we've seen the ability of the federal law and the state law to be interpreted over time to apply to, all kinds of different industries, businesses, and business types. The famous quote, "We don't need a law of the horse." The Constitution has held up since 1788 with broad interpretation. Obviously, things could not have been foreseen into the future the way they are now. And I think that the same holds true for antitrust law. So, I guess my answer to you is it would honestly depend on what that would look like. But moreover, we already have this amazing body of law, which some of us might agree with, some of us might disagree with where it's gone. But stare decisis aside, I think that, we do see the law evolve over time in the courts. So it's a tough thing to say yes or no to. We're certainly open to conversations about refining definitions, which are now just exceptionally broad.
I'd just add to that, if there was going to be additional specificity, I would rather see it done in statute than in regulation, because, I mean, at least in statute, there's a known process for negotiations. Regulation setting in New York State is really sort of a one-way street. But it gets to, one of our concerns, and our general concerns were how broad this is and how expansively it could be used in the hands of a certain attorney general or private litigant. And some of the concepts or comments raised today about either the sectors or the types of behaviors that might be pursued under antitrust legislation just, to me, supports that. The idea to me that while there are Just one example from one of the earlier, I think it was Chairman Thomas was in his introductions talking about, say, the beer market. I don't think there's a sector now where there's more choices available to consumers and an opportunity for entrepreneurs to enter the market than in beer, where there are some dominant national brands. But what we've seen, in fact, in New York State, that this industry has grown, not because of any antitrust enforcement, because the state has actually reviewed and modified its regulations that make it difficult for new players to enter into the market. So my point is that I just heard today, it sounded like a potential for significant mission creep, where there's broad definitions of abuse of power and significant enforcement penalties could be used to tackle a wide range of issues that are probably better addressed through other means.
Of course, I'll point out again, as I did earlier with another witness, that 100 years ago, the exact same arguments about lack of definition were being made about both Donnelly and the Sherman Acts. And so now the law and case law that you're heralding is so wonderful did not have that specificity at the outset either.
That's true. And I think we're in a better position today because we have 120 years of jurisprudence that fills in the blank.
I hear you, but our system of checks and balances allows the legislature to opine when we believe the courts have gone too far in limiting the application of particular laws, right? So that's what we're trying to do here. And so I would just say, look, we're very open, obviously, to your input and comments about ways we can agree to make this better. But the most productive way for that to happen is if we can all understand we're coming from the same place, and understand we may not be, but at least from my perspective, coming at us and saying that everything is working fine and we don't need to change anything is not going to help us get to a product that you might be less unhappy with, put it that way, than just realizing that at least I think this is an important subject area to tackle. But you have to recognize there's something that needs tackling in order to get there.
I think it's incredibly fair to say that we would all agree that we are very much in favor of competition and healthy competition. But I think that it is very important to recognize that one of the things that's made the economy so vigorous in the United States and New York State over the course of time has been allowing the market to make a lot of those decisions rather than allowing government to make those decisions. Government regulation makes sense. And so we are starting in the same place, but end goal, we'll sit down and we'll talk about it.
Yeah, and I look forward to, my time is up, but I'll leave you with this point. I'll note again that all the other countries that seem to have an abusive dominance standard do not seem to be suffering from a lack of competition. So it is not something inherent about this standard that creates a problem.
That's come up a number of times. I know your time is up, Senator, but that's come up a number of times today. And I think it's important if we're talking about the European model, and there's a lot of problems with the European model from my vantage point. But if we take a close look at what Europe has really done with its antitrust laws, it's really used them, at least from one vantage point, as a tool for protectionism. We've seen fights against mergers between companies such as GE and Honeywell to protect European interests that create similar products. So the outcome of the European system has not been necessarily consumer friendly. It has been European-based business friendly. And these are things that we need to pay close attention to as we move forward and we look to models like Europe, because protectionism, I don't think, is any of our goals.
And there's a lot of factors at play here, but I would also point out that over the last 2 decades, the US has outpaced the EU growth, whether you look at EU 15 or EU 25 on GDP or employment. So, I mean, one could argue that the US has had a more vigorous economic growth over the last 2 decades than the EU. Not sure that's a compelling argument one way or the other on this issue of monopoly law, but several other commentators had compared us to EU, and certain players have grown faster of late in the EU. I would think that's because they're coming from a different starting point in the marketplace.
Thank you, Ken. I'm abusing my role now and overgoing my time, so
Certainly.
to be continued.
That's fine, Senator Gianaris. I give you all the time that you need. Senator Kavanaugh has a few questions.
Great, thank you. To continue that dialogue, since Mike Gianaris has been silenced by the clock. Just to note that there has indeed been a lot of economic growth in the U.S., but it has been the great majority of those benefits have been concentrated in the hands of a relatively small portion of the population. Actual standard of living of most Americans has not gone up dramatically in the last quarter century. You, Ken, in your testimony, mentioned a few things that you think the law ought to consider. You mentioned pricing and product quality as sort of the end, the sort of goals of having laws that favor competition. Would you acknowledge that there are other benefits or detriments to consumers that we ought to be able to consider as a legislature when we're regulating?
I think we consider those all the time in other settings. My only point is that, when over the last 40 to 50 years, the focus of antitrust law has been on the net effect on consumers, benefit to consumers, and by the means by which market position has been obtained by effective competitors. I mean, there's a wide range of issues that this legislature addresses every year.
But no, just limit, if I may, just because the time is short, just to in this context, when you say you're noting that antitrust law has considered the benefit to consumers for a long time, but do you, either of the witnesses, agree with the assertion that for the most part, over the long run, that the benefit to consumers has been, the principal benefit that we've been concerned about is price and product quality and other sort of basic economic aspects of the transactions?
I think that they have all improved under the system that we have. I mean, certainly prices have been lowered and the quality of service and product have increased, but I think that the marketplace itself has put certain weights on, other qualities, whatever they are. If they're, social issues, if they're environmental issues, they've all been weighted.
Are you aware of enforcement actions pursuant to federal or state statutes that have gone after companies that seem to have dominant positions in a particular market, where the detriment to consumers was not primarily about price or product quality, but some of these other things you just mentioned?
I'm not sure that there's a legal issue there, so I'm not familiar with prosecution of something that was not, breaking a law. But
I mean, earlier in the hearing, someone talked about the expectation there's a major DOJ investigation on a unilateral actor on something other than price and quality of service. The New York State Attorney General has joined, I believe, 48 other attorney generals against a major tech player on factors other than price and quality. So it does seem like those factors can and are being addressed under existing state.
And should they be? If a company has a dominant position in a given market or a monopoly in a given market, and they are doing harm to consumers in ways other than excessive prices or shoddy products, should competition law try to address that?
I guess I'd like to know the specifics, but just two examples. We and others successfully negotiated legislation 2 cycles ago on privacy protection, privacy breaches. There's ongoing conversations on data breaches. There's ongoing conversations on privacy protection. So I think there's a lot of consumer issues that can be addressed, and they are being addressed outside the
yeah, I will just note that I believe your organization specifically and many other participants in the marketplace have suggested that we should not be putting firm standards in legislation around privacy and other things, because that will stifle innovation, and it's best done at the federal level or perhaps through market mechanisms. So I mean, it's not clear that industry favors hard standards either. I think one of the benefits of this approach would be that over time courts would allow the kind of a judicial process would allow the kind of flexibility that has arisen in the antitrust setting already, where fact patterns are considered over time, current business practices are considered over time, the current state of the marketplace, and you can make a determination whether there's harm. And I acknowledge what I think Senator Gianaris was referencing before, that there may be some benefit to laying out some standards that are more specific, although that'll be up to him in further conversations. But just this notion that, I think that there's a lot of desire to recognize that in this economy in particular, there are many things other than price that people, not many of these tech services are effectively free for the consumer. They're not paying a price to use the service, but as somebody else, one of the other witnesses mentioned, there are a lot of harms and prices that are being imposed on people by dominant participants in these marketplaces. So I see my time's up, and so I'll leave it there, but thank you both.
Thank you.
Thank you, Senator Kavanaugh. I have a few questions for both of you. First off, would you agree that the current law needs to be updated?
I think there's aspects of the current law probably should be updated. I think it was a good point made earlier that criminal penalties were, the financial component was established 40 years ago. Although if you're going to do that, I mean, I've worked on these issues for years, and we've worked, very, very, I think, productively with enforcement agencies on criteria on how both civil and criminal penalties should be applied. So it strikes me that, significantly enhanced criminal penalties should go hand in hand with some clearer legislative directive as to how they should be applied and against what they should be applied. So certainly there's aspects that can be updated.
There are. Okay. So we're just talking about penalties and such. You wouldn't say like definitions need to be changed or anything, given that the world has changed since when our old law was enacted?
Well, it's interesting because, Senator, every example that I heard today so far, including that terrible case about the use of the HIV drug for an intervention. Every one of those cases was prosecuted under some law, be it fraud or manipulation or something like that. These the bad actors were taken care of. The situations were clarified. The fact that there were criminal acts is obvious because he's sitting in jail. So no, I don't think that we need a whole new arsenal of laws. And when you say to redefine, I think what we're ultimately doing in the current draft, at least of this bill, is ill-defining. Market dominance, for example, is extremely ill-defined. And if I could, I would take a second. This morning I left for work and my kids were home for their first day of virtual school. And I apologize, I keep looking down because I'm getting text updates from them. And so on my mind, of course, is a vaccine for COVID-19. I mean, this is like first in my mind all the time because I'd like life to get back to normal. I worry that if a bill like this were the law today, and a smaller firm or even a large firm was first to market with a vaccine, they would, by the very vagueness of this bill, have market dominance because they would be the only game in town. I want access to their product. I want my children to have access to their product. But if I were that company that was first to market with a vaccine, and I saw that New York I could be prosecuted in New York or sued for market dominance, and sued is a big one because the AG may act in one way and private attorneys may act in another way. If I knew that I was running this large risk in New York and nowhere else, I would take the 19 million people in our market and I would compare it to the 7 billion worldwide. And I would say New York can wait until there's 2 or 3 others in the market, so I don't get stuck with market dominance. There are wide effects that a bill like this could have. And so, yeah, I think that it's important if we talk about redefining that we define it in such a way that we're not standing on the outside compared to our 49 sister states.
Well, Lev, I would disagree with that analogy there with a pharmaceutical drug that would save so many lives. There would be obviously exceptions to what we're doing here. But
Senator, if I could, I hear what you're saying, but if a price were set, and you and I have had conversations about price setting in the past on different products, if the price were set at a point that you thought was too high, I wouldn't doubt that you might have a hearing in that case. Am I incorrect?
Of course, we would have a hearing on so many different things, including price inflation, but I doubt that's that's what's going to happen in reality. Let me ask you one question here. You and other witnesses raised the concern that there's no elaboration on what constitutes being dominant. Do you object to the underlying purpose of the proposed legislation to reach anti-competitive conduct by a dominant corporation, short of having to prove the corporation has actually reached the monopoly zone?
I think that would depend on how you define anti-competitive behavior, and the achievement of a 35% market share to me isn't evidence of anti-competitive behavior. I mean, one of the questions I had in my mind in response to one of the earlier panelists' point was, protect small and mid-sized business. Protect them against what? And you would easily get into a situation where you would have to evaluate the effectiveness of the competing parties in a claim. Did I achieve dominance over players A, B, and C through some illegal act, or because I'm so much better? And do you get to a point where the state is de facto regulator of size of business or regulator of pricing, something that I think people would certainly agree that is achievable under the EU structure if they don't actually pursue it, particularly in pricing regulation, something that I think, at least my understanding is, they've been somewhat reluctant to do. But both of those outcomes to me is available to the state under the how broad this bill is.
All right, thank you, you two. My time is up. Thank you so much for sharing your testimony and your answers. Next up,
pleasure. Thanks.
We have law professor Harry First from NYU. He's also an advisory board member to the American Antitrust Institute. Professor, are you on? There you are.
Am
Professor.
I on? Yes, there I am. Okay.
You may start at any time.
Thank you. And I thank the committee for having this hearing and inviting me. I thank Senator Gianaris for introducing this bill. I spoke at the New York State Bar Association's Antitrust Executive Committee annual meeting, that's a long phrase, this past January, as we were considering what amendments should be proposed for the Donnelly Act. And I spoke in favor of changing the Donnelly Act and allowing for abuse of dominance as the correct standard for single firm behavior. So I'm glad to see this is now actually in a bill. So thanks. I will say, not just my original idea, Herb Hovenkamp, probably the leading scholar in antitrust today, wrote a paper 10 years ago suggesting the Federal Trade Commission adopt to some extent an abusive dominance provision under Section 5 of the Federal Trade Commission Act. So this is an idea, frankly, whose time has come. Speaking of time, since I am limited, I have submitted a statement to the committee that proceeds in 3 points. The first being that a prohibition on single firm behavior should be added to the Donnelly Act. There is none now. Second point is, well, what should it contain? Should it simply copy, shouldn't say simply, but should it copy, duplicate federal antitrust law and prohibit monopolization? Or should it do something more, which New York certainly can do? As I've said, I believe in the abusive dominance standard, and I'm glad to come back and talk about that more, both points, if the committee has questions about that. But I want to concentrate on the third point that I tried to make in my written remarks, because it goes to a thread of conversation that's gone through some of the previous discussion, particularly the discussion that just preceded me. And my concern actually isn't with adopting this bill. I hope that it will pass. My concern is, will it be effective? Will the bill be enforced appropriately by enforcers, but particularly read appropriately by courts? So narrow judicial readings of Section 2 of the Sherman Act have frankly undermined its ability to deal with single firm behavior. Those readings are relatively recent, but they're very strong. And I'm concerned that New York courts may not do any better under this. So I propose 4 things which I think are relatively simple, but I urge the committee to think about them carefully. The first is to require either guidelines be written by the Antitrust Bureau of the Attorney General's office or formal regulations. Now, guidelines are something that a lot of antitrust enforcers use to tell business firms and the courts what they think is appropriate. And I think that the Bureau could do a really good job of defining what an abuse of dominance is. And I think this will help courts believe that this is not standardless, that it's not such an open-ended provision that it could mean anything. And I'm worried that courts will will construe it narrowly out of the fear that it's too open-ended. The second thing is I would eliminate criminal liability for abuse of dominance. Criminal liability, as it conventionally is in federal courts under the Sherman Act, is actually confined now to price fixing, market allocations, even though Section 2 is criminal. That's the conventional wisdom. There hasn't been a major criminal prosecution for monopolization since 1940. I'm worried that courts, seeing this as a potential criminal statute, will construe it narrowly, even in the civil context. Well, I don't think we need it. I would eliminate it. Third thing is I'd remove the provision on monopolization. This obviously, as prior speakers have said, is broader. And I'm worried that this will invite conservative lawyers and judges to focus on the monopolization part, better known, and may never develop the other part. And the fourth thing is I would not eliminate the private action for abuse of dominance. I think Tim Wu suggested that. I would delay it. I delay it for 3 years. Let the Bureau write the regulations or the guidance, and then we'll know what it is. Let's not develop this in the context of private cases. So I'm glad to talk further if you have questions. And again, thank you for this opportunity.
Thank you, Professor. Senator Gianaris.
Yeah, hi, thank you, Professor. I just have a quick question. I know we have more witnesses to come still, so this is getting on in the day. You said remove the monopolization provision. And is that because in essence it would just be being replaced? You want a clean break with the previous standard? Is that the idea? So that we can start developing the abuse of dominance jurisprudence?
Yes.
Without being weighed down by the rest of it?
That is the idea. I think there are cases that the FTC, for example, has litigated where they have a broader theory and a narrower Section 2 theory. And they want to win their cases when they get into court. So they end up focusing on the narrower theory. This just happened in the Qualcomm case, actually, that I cited in my testimony. And then they lost on the Sherman Act theory and never developed the broader one. Don't do it. There's no reason actually for New York State to duplicate Section 2. It will serve no function. Abuse of dominance is broader. It will catch anything that Section 2 would catch today, and obviously more.
And interestingly, on the regulatory specificity, I mean, we're hearing a lot from opponents of the bill that that's needed, but you're saying it's needed to keep judges from sympathizing with that argument.
I think that's right. They will not know. You know, when the Sherman Act first was litigated, restraints of trade had been known to the common law for years, and that's why the courts upheld it. And they upheld it against constitutional challenge on vagueness, on due process grounds. They had background. Now, abuse of dominance is used in, let's say, 100 jurisdictions around the world, and it means something different in one or the other. We're talking all about Europe, but it's used in China, in India, in South Africa, all over the world. What's a court to look to? What's private counsel to look to? So I think this will help them mount a stronger due process challenge, or courts construing it narrowly to avoid a due process challenge. So let the Bureau look at it carefully, think about it, hold hearings, better, I hate to say it, it's better than having the legislature do it because it's easier to change. It may take a little while to get changes in the Donnelly Act. It's taken a long time to get these. Let the Bureau do it. They have expertise. They can change them more easily if they turn out to be wrong. They can hold hearings. They can really beef this up in a way that courts will then look at it and say, well, you know, they know what they're talking about. This is what's happened in federal courts with Justice Department guidelines. And it's been very useful in the merger area. And I think it could be similarly useful to have an effective bill. But I think the direction to do it from the legislature will also help to insulate this bill against attack, because then judges, if it's attacked the next day, judges can say, well, let's wait and see what the Bureau does. And this has happened in other areas, by the way, in the regulation of electric utilities. This is exactly what happened. So I think this will help a lot. It will give the opponents, it's a sort of be careful what you ask for. Give the opponents what they want, because in the end, it's going to help the bill.
Right. Great. Thank you so much.
Thank you.
Thank you, Professor. Senator Kavanaugh has a few questions.
Great. Thank you, Professor. Your testimony has been really helpful.
Thanks.
We've had a number of witnesses comment on the effect on innovation, on economic growth of antitrust laws and enforcement of them. Are you aware, are there sort of reliable studies of that question, that academic studies or you know, business, in the business context, that kind of demonstrate whether antitrust helps or hurts competition and growth?
So this is one of those deep questions in antitrust, and subject to a long debate and different views. There is a recent empirical study which purports, and I say purports because it's a difficult study, but it seems to show that countries with stronger competition law have more innovation. And this was based on a worldwide database of 130 jurisdictions. So I think there is some question about that. By and large, economists today believe that monopolists are not great innovators. They are engaged in an effort to protect their businesses from disruptive innovation. And so they innovate poorly and slowly. So monopoly is not great, particularly once you've got it, for innovation. And I think there's a fairly broad consensus on that. The empirics are sort of a little, you know, unclear maybe. And of course the debate, you know, does Europe have more innovation because it's got more antitrust enforcement? I'm not sure that's the case, but they certainly have a lot of innovation, and a lot of their antitrust enforcement is, you know, not against US firms. I really have to disagree with that notion. Cases I cited in my comments were all involved European firms under the standard of abusive dominance. There's a lot of innovation in Europe. The economists seem to agree there's better income distribution in Europe, whether that's associated with antitrust or other things, again, a debate. Antitrust has difficulty in taking innovation in and trying to figure out what to do with it. And the Europeans have been attentive to that, particularly in some recent merger cases. So I don't think that an abusive dominance standard will stifle innovation at all.
And just to sort of complete the circle, and growth, I mean, economic growth overall, any indication that, like, I mean, theoretically, I guess you could have a relatively uninnovative company that nonetheless gives the people what they want and grows rapidly, like as we've seen. Is there any strong evidence one way or the other about whether overall economic growth?
I think that's a great question. There are lots of determinants of economic growth, dealing with lots of things other than competition law and policy. So it's hard to tease out the exact effect. I will say this, that to the extent that the antitrust laws are enforced in a way that allow disruptive firms to enter markets and compete, it seems to me, by definition, that's going to get you both innovation and growth. Sometimes we've used it. The Microsoft case was an example where we tried to use it. Europe does try to use it. We've got a number of policies. So I think in that sense, if abuse of dominance means that you can't deprive competitors of a fair opportunity to compete on the merits, which is how it has been defined and used in Europe, how the antitrust laws used to be used more in the US, frankly, we will have more vigorous markets. We will have growth. But teasing out that exact line when there's so many other policies that get involved in growth is, a hard lift, heavy lift.
Thank you. I'll end there. Appreciate it.
Thank you, Professor. In your opening statement, you talked about delaying the private right of action 3 years. Can you explain further why you would like that to happen?
So one of the phenomena in federal antitrust development, legal development, which a number of people have pointed out, is that a lot of these what I would call bad decisions or narrow decisions have taken place in the context of private litigation. Judges are often skeptical of private lawyers and private litigation, and they sometimes think that these are firms and lawyers particularly just out to make a lot of money. Whereas, although they can be skeptical of public enforcement, there is the sense that the public enforcers are out for the public. I'm less skeptical of the private right of action, but I understand the impulse. So some of the cases I've cited, for example, the Trinco case, private case. And the court saw a big recovery and they were worried about it. Now, I'd rather develop abuse of dominance in the context of a case framed by the Antitrust Bureau, presented in the public interest, and let that develop a little bit, the guidelines, let that develop, and then let the private parties come in. They'll know how they've been harmed. Yelp knows how it's been harmed. It's complained to government enforcers around the world about it. So let them in, that's a good idea. But I think if courts see that a private plaintiff in front of them complaining about what a court may think of as just vigorous competition, we may get very narrow decisions. So I would call for a pause. I don't want to make it sound COVID-like, but a pause, but not, I would leave it there. Private enforcement is very important for the enforcement of the antitrust laws.
Second question I had was, if Senator Gianaris were to eliminate criminal liability for abuse of dominance from the legislation, is the civil liability sufficient to compel compliance with the legislation, or will civil liability just be the cost of doing business?
Well, you've already heard testimony that fines on corporations are ignored. Fines are what you impose in criminal cases on corporations. So I don't know what to do with that sort of argument in a sense. Of course, the cost of doing business, but the government enforcers can ask for injunctive relief. They can ask for courts to order a change in business practice. Business companies don't like that. Maybe some forms of structural relief, perhaps. The state can itself seek damages. And eventually, as the private comes in with treble damages, some people have argued that that's a stronger deterrent. Remember, fines not trebled. However it's computed, it's not going to be that. That's a strong deterrent. So on the other hand, we haven't used the criminal penalty in monopoly cases, even in monopoly cases. So I think it's sort of leaving in something that may never be used, but may affect how the courts see the cases in front of them.
Thank you, Professor, for being on with us and for all those answers to our questions today, all right? And I'll let you go after this. So next up, we have—
My pleasure. Thank you very much, by the way. Thank you.
Thank you. Next up, we have Shoal Sussman, a legal fellow with the Institute of Local Self-Reliance. Mr. Sussman, you're on. How are you?
Good morning.
Good afternoon, but if it's good morning in your part of the woods, that's fine.
That's true.
Welcome, and you may begin, whatever.
Thank you, Chairman Thomas and members of the committee for inviting me to appear today on this pressing issue. My name is Shaul Sussman, and I'm testifying on behalf of the Institute for Local Self-Reliance, a national organization that works to advance policies that disperse economic power and build thriving, equitable communities. The pandemic has exposed the devastating impact of today's extreme level of corporate concentration on the people of New York. The wealth of the few has reached extraordinary levels, while average worker earnings have barely increased, leaving many New Yorkers with no cushion to blunt the force of this downturn. During this unprecedented times, our organization is in regular contact with small business owners who are now struggling because of their inability to negotiate with big businesses that control their industry. When concentration of business has reached extreme levels in the past, states have often stepped in and played a key role in acting on their own in a way that spurred the federal government into action. The state of New York has a long and well-documented history of fighting monopolies and curbing anti-competitive corporate power. Today, we call upon the legislature to take action and reinvigorate its anti-monopoly laws in the face of a second Gilded Age and the rise of the digital robber barons. For decades following the passage of the Sherman Act in 1890s, New Yorkers could rely on our federal government and courts to effectively fight against and break monopolies. But unfortunately, in the last 40 years, the federal government and judiciary eroded and overturned many past anti-monopoly legal precedents. Monopoly power once again came to rule our communities as a result of government inaction. Research has found that corporate concentration is causing economic inequality, wage stagnation, a sharp decline in new business formation, and sluggish innovation. Monopoly power undermines small business. It's harming dairy farmers in central New York and leading to vacant storefronts in small towns and urban neighborhoods alike. It's harming working people by foreclosing competition over labor markets and forcing many New Yorkers to rely on gig economy jobs. Monopolies also fuels racial injustice. Monopolies are less efficient. A recent report published by ILSR has demonstrated that the growth of Amazon's logistics business resulted in a per unit increase in shipping and delivery fees Amazon charges from sellers who use their services. If we assume for the sake of argument that Amazon does not charge inflated monopoly prices for these services, this increase in fees must demonstrate that Amazon has become less efficient. It is now charging more money from small businesses for the same services. As the legislative findings make clear, monopolies are dangerous, and after they are established, it is typically too late to repair or mitigate the damage which has been done. New York cannot and must not wait for the federal government to act. Monopolies are harming our communities and small businesses, and the current COVID crisis only magnifies and intensifies the harm. Senate Bill S-8700, Abusive Dominance Standard, would fill critical gaps in today's antitrust law and jurisprudence. By imposing lower market share thresholds for demonstrating market power, while simultaneously expanding the number and types of conduct that will be deemed anti-competitive, the law will capture and prohibit many types of unilateral conduct, such as monopoly leveraging and predatory pricings that firms engage in, but are virtually impossible to prosecute under current federal standards. By setting bright line rules and clearly articulating what constitutes abusive dominance, New York will become a leader and an example for future federal and state legislation. One such rule should be the imposition of a presumption of anti-competitive behavior when a certain market share or market power threshold is met. Another is setting lower market share thresholds under the abusive dominance standard than those demanded by courts under the Sherman Act. On behalf of ILSR, I thank you for your focus on this issue and urge you to pass this legislation. Historically, New York has been at the forefront of the fight against monopoly power. It is now time for New York to reinvigorate its antitrust laws and lead the anti-monopoly movement once again.
Thank you, Mr. Sussman, for your opening statements here. I just have one question for you. A number of witnesses who are against this bill talked about how this would stifle competition and would actually undermine small businesses. Do you agree with anything they've said there?
I largely disagree with these comments. I think that what we're seeing now in when we investigate or look into many of these major corporations is actually that their activities are stifling innovation of small entrepreneurs. The case that we study in the organization is Amazon, and in that case, we see that Amazon, with its increase of dominance and its increased market share, has imposed higher fees and is charging the consumers of services like fulfillment and logistics higher prices. So if 5 years ago, a small seller, someone that wanted to start on Amazon, an e-commerce business, had to turn over roughly 16% of their revenue to Amazon, now it's about 30%. So what happens is a larger percent of that revenue goes to Amazon and less of it stays with the innovators or the entrepreneurs that want to engage in e-commerce or to develop new products and sell them online. So I would disagree with the argument that it is stifling innovation if we will impose some kind of higher standard.
Thank you. Another question I have is a number of witnesses who are, criticizing the bill talks to the definition and how it's too broad. What do you have any comments about the definition that's been in the bill?
So I think the approach that could be taken here is to add certain definitions either by the legislator or by the Attorney General. I would join Professor's first wariness of allowing the judiciary to impose their own definition to what constitutes abuse of dominance. Judges are not trained to read or extensively cite European laws. They're trained and deal exclusively with the American federal standard and state antitrust laws. And there is the concern that they will gravitate towards existing American precedent and adopt many of the decisions or opinions that were issued under the Sherman Act and impose them on the abuse of dominance standard, as opposed to developing new and more novel approaches of interpreting abuse of dominance, or even looking towards what is done in countries like China or Canada, for instance.
I mean, I'm not sure if there are any judges listening into this hearing. They might disagree with you about their training part. But thank you so much, Mr. Sussman, for your testimony and answering my question.
May I add a few more comments?
Sure. I have another 2 minutes, so go ahead for the next 2 minutes.
So one is about the private right of action. I think it would be important to keep that in the bill. The danger of allowing only the state to bring this type of action is regulatory capture. And, we have experience from the federal level where you see, the revolving door effect and many officials in the FTC or the DOJ leaving and working for companies that they are regulating. And by allowing this authority or, vesting this authority exclusively with the AG, there is a danger of regulatory capture, there's a danger of lobbying, etc. If there is a concern that private plaintiffs will bring only profitable cases, it would be the role of the AG to bring the unprofitable cases. And it remains in their discretion to bring those cases. And just one more point, I think that was made earlier about the intention of the Sherman Act and the Donnelly Act. I think that Senator Ramos mentioned small businesses, and I just wanted to mention that Judge Learned Hand from the Second Circuit issued an opinion in which he said, throughout the history of these statutes, it has been consistently assumed that one of their purposes was to perpetuate and preserve, for its own sake and in spite of possible cost, an organization of industry in small units which can effectively compete with each other. And this opinion was endorsed twice by the Supreme Court. So to say that throughout the history of the Sherman Act or the Donnelly Act, there wasn't any type of concern towards small businesses is just an incorrect reading of the law.
All right, thank you so much. It's been long since I've heard Justice Learned Hand. Dave.
1L of law school.
Yes. Thank you so much, Mr. Sussman. Next witness that we have is Sally Hubbard, the Director of Enforcement Strategy at Open Markets Institute.
I am here. Do you see me?
I see your picture, but do not. Ah, there you are.
Okay.
Welcome. Welcome.
Video. Okay. All right. Do you see
Start
my?
whenever.
Okay. All right. Great. Okay. Well, Chairperson Thomas and members of the committee, thank you for inviting me to testify. My name is Sally Hubbard. I'm the Director of Enforcement Strategy at the Open Markets Institute, and I'm the author of the forthcoming book, Monopolies Suck: 7 Ways Big Corporations Rule Your Life and How to Take Back Control. I previously served as an antitrust enforcer at the New York AG's office. I believe the tech giants are each violating the federal antitrust laws as those laws are currently written. And as you know, the New York AG has the power to enforce those laws. But the courts have spent decades nearly gutting them and paving the way for concentrated corporate power to take over America. Big tech's enduring dominance is fueled by monopolization that violates Sherman Act Section 2. But because of court decisions, Section 2 cases take too long and cost too much money. Anyone seeking to claim their right to a competitive marketplace must spend huge sums of money to hire economic experts. Monopolist victims can rarely afford to sue them, and the enormous expense also affects enforcers' calculus of whether or not to bring cases. New Yorkers deserve an abusive dominance standard that makes a clean break from Section 2 legal precedent. New Yorkers need a new tool to fight monopoly. A monopolized economy harms all New Yorkers. Workers are harmed by highly concentrated labor markets, which limit job options, deprive employees of bargaining power, and depress their pay. When wages go down or stagnate, female employees and employees of color are the hardest hit. Concentrated corporate power breeds rampant inequality. And as monopolies use their muscle to extract the fruits of everyone else's labor and impose taxes on those who must use their essential infrastructure, while avoiding paying their fair share of taxes. American businesses of all sizes and would-be entrepreneurs are also harmed when digital platforms control the game and play it too. Abuse of dominance by digital platforms is fundamentally a threat to the American dream. The American dream is defined as a set of ideals, democracy, rights, liberty, opportunity, and equality, in which freedom includes the opportunity for prosperity and success, as well as an upward mobility for the family and children, achieved through hard work in a society with few barriers. Ours is not a society with few barriers when digital platforms pick the winners and losers of our economy, particularly when they pick themselves as the winners. Antitrust law aims to stop established companies from shutting out competitors. If entrepreneurs and business people bring their hard work and the best products and services forward, an open and freely competitive market rewards them with prosperity and success. To their credit, the big tech platforms started on their paths to dominance with innovation, but they're each more than 15 years old and have dominated their arenas for more than a decade. Their enduring and expanding monopoly power has less and less to do with competition based on merit. Google, Amazon, Apple, and Facebook have reached their controlling positions in large part through hundreds of acquisitions, many of which were illegal. The tech giants are each following Microsoft's playbook using what I call platform privilege, the incentive and ability to favor their own goods and services over those of competitors that depend on their platforms. An abusive dominance standard would prevent discrimination, meaning the platforms must offer equal access on equal terms to all. This is not a radical idea, but is rather a core tenet of our democracy. Let me be clear. I believe each of these corporations provides useful, high-quality services to some portions of the public, but these benefits do not make illegal monopolization okay, nor do they justify monopoly business models' harms. Luckily, we've overcome these same problems before in our nation's history, when the American people rose up against the Gilded Age robber barons with their seemingly insurmountable economic and political power. Speaking to my fellow New Yorkers, if you're listening, in order for your elected representatives to stand up to monopoly power, they need to know that you've got their back. The tech giants have endless lobbyist funds, but we, the people, can once again rise up and prevail against monopolists. Our economy, businesses small and large, and consumers would all benefit from swift action by New York's legislature. Consumers benefit from the choice, innovation, and quality that robust competition brings. Consumers are also citizens who benefit from the free flow of speech. They are the workers and employees of companies that benefit when platform extraction ceases. And they are the entrepreneurs who deserve a shot at the American dream. Thank you for letting me share my views today.
Thank you, Sally. Senator Gianaris, do you have any questions?
Yes, thank you, Sally, for joining us and for your insights. Just a quick one. As I listened to all the competing testimony today, it seems the different views of this bill, one side says it will stifle innovation, the other says it will enhance it. So I know your testimony was largely on one side of that issue, but can you shed any light to settle that question for us? Because they're diametrically opposed opinions about the same thing.
Sure. I mean, I think we can look at our last successful monopolization case, which was US v. Microsoft. And most people agree that if that case didn't happen, Google would not exist today. Because what Microsoft was doing was it was saying, we have a monopoly on the operating system, so therefore you need to use our browser. We're not going to give Netscape a shot to just compete based on merit. We're going to ram our browser down everyone's throats. Antitrust enforcers stepped in and stopped that practice from continuing. If they didn't, and Microsoft would have just said, okay, you'll take our browser, and consumers and computer makers, everyone, you'll also take our search engine, right? So, you know, the problem is that we waited too long to enforce the antitrust laws again. But every time we've seen antitrust enforcement against major companies, we've seen waves of innovation. I mean, if you look back at history in terms of what happened after the AT&T was broken up, IBM enforcement, all of them unleashed innovation. So unfortunately, a lot of the folks that are saying it's bad for innovation are folks that are on the payroll of these big tech companies, and not all of them disclose that. Some of them have really deceptive names of their think tanks, and they act like they're on the side of people, or they're academic. You know, it's really disturbing how many academics there are. None today, not my professor, Harry First, who, by the way, taught me antitrust at NYU Law 20 years ago. But there's a lot of, well, I don't know what's going on with him today, but all I'm saying is there are a lot of talking heads that are conveying this innovation, you know, myth that I think is largely being funded by the tech platforms themselves.
It's funny you say that, since our next witness is the Progressive Policy Institute. Which
Yeah,
doesn't
I may have been thinking about that.
so, you know, you can pick whatever name you want.
Yeah, I have to say, as a New Yorker that has been working in DC for many years, I was pretty horrified when I first came to DC and learned this practice of naming organizations in what I consider to be a deceptive way. And it does make me unhappy to have them on my turf here in New York, where we say it like it is and we speak the truth in New York, right? And this is not Washington, DC.
We know how to cut through the BS here in New York anyway. So thank you for your testimony. So I appreciate it.
Thank you, Sally. Thank you, Senator Gianaris. I have one question here. How will strengthening antitrust law check the power of these big tech companies? And how does that help with the workers that you talked about, where they are being abused by monopolies?
Sure. My colleague Daniel Hanley and I actually produced a report last week or 2 weeks ago on Amazon worker surveillance that I recommend everyone checking out. It's very, very disturbing, incredibly dehumanizing treatment of Amazon workers. And, you know, basically what happens is as workers have less and less options for employers, they have less and less bargaining power. And, you know, one of the ways that employees can exercise some bargaining power against employers is the threat of going to another job. But as our economy has gotten highly consolidated, there's less and less options and less mobility among workers and less bargaining power. Another main way that workers exercise bargaining power is through unionization. But we've seen a lot of these tech giants, with their incredible muscle and resources, actively suppress unionization, including Amazon. We wrote about that in our report, that they're actually using their surveillance technology to track workers, ensuring that they're not gathering. And, even recently just had a job listing hiring an intelligence analyst to track unionization data. And then also it was recently reported have brought the former head of the NSA to their corporate board, the one that was the subject of Ed Snowden's whistleblower complaint. So we have some really abusive and troubling practices, and the larger these companies get, the less options workers have, the less ability they have to unionize, and also the less political power they have in seeking regulations to protect them. Because as you all know, that tremendous economic power translates to political power in terms of labor regulations and rules to protect workers.
Thank you, Sally. Senator Kavanaugh, do you have any questions?
No, just thank you for your testimony. I declined to take Professor First Class, and that was probably a mistake. So I'm paying the price today, but thank you for your testimony. All
right, thank you.
Could I disagree with my professor in one measure? Sorry, Professor First, but I do agree that we would want the state AG to be the one that's really setting the contours of this regulation through rulemaking and guidelines. I think a 3-year delay on private enforcement is too long. What we have here is a tremendous mismatch of resources, with these tech giants having just endless resources for litigation. And I think having private litigation as a supplement to government litigation is really a helpful way to deal with those resource constraints. I think you could wait until those guidelines and rules are issued, but I think a 3-year timeframe is a bit too long to make private litigants who have been injured wait to get their relief.
Thank you, Sally.
Wait, I have one more thing I want to say. A lot of folks have said during this day that these companies are not monopolies, and I just completely disagree with this. The definition of monopoly power is the power to control prices or exclude competition. That is the definition of monopoly power, and you should be able to prove that with direct evidence. Direct evidence, for those who've gone to law school, know that direct evidence is stronger than indirect evidence. So the emphasis on market share is actually a form of indirect evidence. It's a proxy for monopoly power. If you can show that they have excluded competition and they have controlled prices, which you can show, there's tremendous evidence that each one of the major tech giants have done this, you can prove monopoly power. So I don't think that we have a situation where they're not monopolies. And in fact, I think most of these tech giants have monopolies in multiple markets. And I think, a lot of the market definitions that we see from the people who are the mouthpieces of big tech, where they make the percentage look so small, that's because they're defining the market in an overly broad way. They're not defining it the way it's supposed to be defined under antitrust law, which is looking at the realm of substitutes and switchability that constrains a monopolist from either raising prices or reducing quality. So, it's what I like to call it is the irrelevant product market. When you hear things like, all e-commerce or all digital advertising, those are irrelevant product markets. Because if you think about it, if I am a small business and I need to pay for Google ad just so my business can show up when people search for my business's name, right? It's like a tax that Google is charging on all small business. Just to get your name to show up, you have to pay thousands of dollars in Google ads to be found under your own, even if someone searches under your own business name. Saying that the relevant product market for that type of conduct, that problem is all digital advertising, is just way too broad of a product market, right? Because I cannot say I'm going to put an ad on Facebook to make up for the fact that no one can find me when they search for my name on Google, right? So you have to really look at, when you're defining what is the relevant product market and you're looking at the exclusionary conduct, you have to look at, when this exclusionary conduct takes place, what are the substitutes that the people who are being harmed, the consumers or the suppliers, that they can switch to when they're being harmed? What's the realm of companies that constrain the monopolists from abusing people? Okay, that's how you define the relevant product market, not these, and if you look at every antitrust case, it's not all e-commerce or, it's things like, Microsoft was the Intel compatible PC operating systems. Okay, that was the market definition. Right. So anyway, just trying to make the point that we have direct evidence of monopoly power. They are monopolies. Every single one of these companies are monopolies, actually in multiple markets. And two, these percentages that you hear are just based on completely irrelevant product market definitions that would never hold up in court.
Thank you.
I hope my colleagues appreciate how well I used my 5 minutes there.
Yes, I know. Thank you, Sally, for your testimony and for answering our questions. The next witness that we have is Alex Stapp, the Director of Technology Policy from the Progressive Policy Institute.
Hello, can you hear me?
Yes, I can. Thank you, Mr. Stapp, for coming on today. You may start at any time.
Thank you very much. Okay. Thank you for inviting me to testify today. It is a great privilege to be able to share my thoughts with this esteemed committee. My written testimony has more detail, but in the interest of time, I will focus on a few key points. The proposed changes to New York State's antitrust laws, while laudable in their intentions, would likely make American consumers worse off in the long run. The urged fall of the European Union standard is misguided, as the EU's regulatory and competition framework has failed to produce a tech sector close to the size of the US's. Rather, the EU regulators and legislators should be asking what about the US system is worth copying so that they can create a vibrant tech sector that produces more innovative products for consumers and high-paying jobs for workers. Here are 4 points I hope you consider during this legislative process. Number one, big tech companies aren't monopolies. There's a difference between the layperson's use of monopoly and the technical meaning of the term. In casual commentary, monopoly is often used interchangeably with other terms that mean large or big. But the term has a much more precise legal definition developed in case law. According to DOJ guidelines, a company has monopolized a market when it has maintained a market share in excess of 2/3 for a significant period, and market conditions are such that the firm's market share is unlikely to be eroded in the near future. And as the Attorney General mentioned earlier, switching to an abuse of dominance standard could find liability with as low as 40% market share. But most tech companies don't even meet the lower abuse of dominance market share threshold. Google has 29% of the US digital advertising market, Facebook has 23% of the US digital advertising market, and Amazon currently has less than 40% of the US e-commerce market. And based on Ms. Hubbard's previous comments, I would love to discuss these market share questions in further detail, hopefully in the follow-up time. But critics of big tech often try to define arbitrarily narrow markets to show a market share in excess of 2/3. That's why you'll hear that Google has 90% of the digital search advertising market, or a large share of the US digital display advertising market, or the US digital video advertising market. What these critics fail to show is why these should be distinct antitrust product markets. Advertisers maximize return on investment. If prices increase in one advertising channel, they likely substitute to spending to other channels. If anything, the simultaneous rise of digital advertising and fall of print advertising, while other advertising channels have remained flat, suggests that the US digital advertising might be even too narrow of a market. Because it seems that advertisers are substituting digital advertising for print advertising. A good rule of thumb in antitrust is that the more adjectives someone tries to use to define a market, the less likely it has any relation to economic reality. Next, big tech benefits consumers. Let's look at consumer harm. According to DOJ guidelines, an antitrust enforcer must show that a company has used its monopoly power to harm society by making output lower, prices higher, and innovation less than it would be in the case of a competitive market. But prices in digital markets have been falling or at zero for years. The price of digital advertising has fallen more than 40% in the last decade. The price of books has fallen more than 40% since 1997, the year Amazon went public. Social media messaging apps are priced at zero. Apple's 30% App Store tax is actually the going rate for platform commissions. While these prices for these services are low or even zero, consumers value them a great deal. Number three, big tech invests in innovation. Innovation is difficult to measure directly. One proxy variable we can look at is spending on research and development. A complacent incumbent harvesting monopoly rents tends not to invest much in the future. By contrast, in a competitive marketplace, even the dominant firms are nervous they will be unseated by nascent or potential competitors. To prevent that from happening, they invest in the next generation of technology that will benefit consumers. The top 5 companies in R&D spending in the US are tech companies. Another metric that's worth looking at is capital expenditures. The line of reasoning here is similar. A monopolist secure in its market position would rather distribute profits to shareholders than make risky investments. According to the Investment Heroes report by Michael Mandel and Elliot Long at PPI, half of the top 10 leaders in capital expenditures were tech companies. Number 4, the American public has a favorable view of big tech. In survey after survey, Americans say they approve of the tech companies, trust them more than other companies in other industries, and don't think politicians should prioritize regulating them more. In conclusion, this data shows that there is not an antitrust problem in tech that needs to be solved, and new legislation would only be detrimental to consumers in the long run. Thank you for your time.
Thank you, Alec, for your testimony. Senator Gianaris, do you have any questions?
I do. Thank you, Chair. I don't know how long you've been paying attention to the witnesses today, but there's a fair amount of testimony about AstroTurf organizations, and we always like to know who we're talking to. So can you speak a little bit about your interest in this subject? Are some of your members part of the industry, or where exactly do you represent when you're speaking to us?
Yeah, thank you for your question, Senator. I'd be happy to answer that. So just to give broader background on the Progressive Policy Institute, we're a center-left moderate think tank here based in DC. We've been since the early 90s, and so I think as the term progressive has evolved over time, maybe that's part of that terminology slippage that you might see there, but we're generally associated with the Blue Dog Democrats or the New Dems in Congress. I work with the moderate wing of the party. And in terms of funding, we receive a wide range of funding from individuals, foundations, and corporations. And in my role on research, I'm not privy to the full donor list or who gives how much money. What I do know is that no individual donor contributes more than 10% of our annual funding. And that I do believe, based on public disclosures, that some tech companies do donate to us, as well as some telecom companies, which have conflicting interests with tech at times. And so that's kind of how our donor base shakes out.
Great. Would you guys be willing to make that information public so we know which, like if your funding is coming from big tech at the same time you're advocating on this issue?
Yeah, I can definitely discuss that with my leadership. It's not my call to make personally, but I can definitely discuss that with our leadership.
It would certainly be helpful because we pretty much know where everybody else is coming from at this hearing. And, for a self-described moderate group to be calling itself progressive is just kind of a curious frame to use. And it's as simple as, you could take back to your leadership, it's as simple as releasing the relevant IRS forms for public consumption so we could actually see what's going on. The other thing I would mention on this substance is everyone that's testified has mentioned that all significant antitrust actions that were successful have been followed by waves of innovation in the relevant industry. And yet you seem to be arguing the opposite. And like we've had professors from Ivy League colleges and all sorts of experts say the same thing, and they cite the phone company breakups, they cite the Microsoft case, without which I understand Google itself would not have existed. And yet somehow is something different about today's day and age, that an antitrust case would stifle innovation as opposed to promoting more of it as it historically has?
Yeah, thank you for that question. I actually disagree with the historical analysis. I published a paper. I believe Tim Wu is obviously the leading thinker on this thesis, and he's published a paper looking at the IBM case, the AT&T case, and the Microsoft case. I published a paper myself going through those historical periods, and I think there are alternative explanations for what went on there. But just to pick one example off the top of my head, let's look at the Microsoft case. One, the government ended up winning, ended up being settled, right, for terms that did not include a breakup of the company. Microsoft, so the case was settled in 2001. Microsoft went on to increase its market share in the browser market with Internet Explorer, becoming a virtual monopoly with greater than 90% of the market over the next few years following that case. And so it didn't prevent the kind of conduct that people were worried about in the 1990s in terms of crushing Netscape or Microsoft monopolizing the browser market. And I'll note that Facebook and Google were not browser companies. They ended up being coming through the open web. And so, and then only 5, 6, 7 years later did browsers like Firefox and Chrome come along to compete. And they were able to, by having a better product, start slowly displacing and taking market share from Internet Explorer. But I think really was the open web and a new platform that came along, not a new entrant just directly challenging the incumbent monopolist or dominant firm. Often innovation comes from a new, much larger platform that the incumbent does not understand well or doesn't have the proper incentives to go out and compete in because they want to control their one domain. And so we see that from IBM monopolizing mainframes. IBM still has monopoly mainframes today. They have greater than 90% market share. Microsoft still has greater than 80% market share in PCs, but they missed out on transition to mobile. And so I think similarly, the dominance you see in mobile today will shift with new platforms in the future.
Well, I would think that argues for the need for more aggressive enforcement, not some suggestion that the enforcement that occurred wasn't. Are you actually saying that the case against Microsoft was worthless or shouldn't have been brought because it didn't lead to any productive consequences?
Yeah, I'm saying that in terms of the new rise of big tech today, the leading firms in terms of Google and Facebook we see, were due to the open web, not due to the antitrust case.
Right, but to answer my question, if you wouldn't mind, do you think there was benefit to that case being brought?
I don't believe the cost outweighed the benefits in that case. No.
Wow. Okay. Thank you.
Thanks.
Thank you, Alec. I have a question here for you. In your opening, you stated that big tech aren't monopolies. As a result of these larger companies being investigated by federal entities, is that each has started to point fingers at the other as violators of antitrust law. For example, Facebook reportedly accused Apple of charging monopoly rents. Why are big tech companies accusing each other of violations of antitrust law if big tech is saying there are no monopolies in this sector?
Yes, thank you, Senator. That's a great question. I think that's kind of a trend you see across industries, not just within big tech. And so I think oftentimes when an individual company comes under scrutiny, they like to point the finger somewhere else and say that look at them, maybe consider using your constrained resources to go after that company. And it's not just the big tech companies pointing at each other. It's often smaller tech companies or companies in other industries that are funding organizations to go after the biggest of the tech companies. And so I think we should take that with a grain of salt in terms of general rent seeking or just being skeptical of claims that people bring. And we should look for evidence of these things before we go through with them. And so that's just a concern I would share.
All right. Senator Kavanaugh.
Thank you. So you took pains to assert that the companies that we're talking about today are not monopolies because of the, and I guess it's a fair point that whether you define it how you define a monopoly depends on the market you're talking about. Why is that? Why should that be so relevant if we're looking at legislating? Why should we not ask the question, as I think one of the prior witnesses suggests, which is, does the company have the power to engage in behavior that is contrary to the interests of consumers or the general public? And are they engaging in that behavior and construct laws that are intended to address that?
Yeah, that's a great question. I think the way I think about antitrust law in general and the goal of antitrust is what are we trying to achieve here? And often I think what antitrust has shown is most capable of achieving is better outcomes for consumers. And so I by no means am saying there are no problems with big tech and that they don't need oversight, scrutiny. So there are problems with privacy. And our organization supports federal privacy legislation. There are problems with election interference, foreign interference in our elections. We need more transparency and disclosure and requirements based on foreign advertising. There's problems with misinformation. You can go on down the lines, but as you list out the concerns that most people have with big tech, they're not narrowly concerned with consumer welfare issues. So things like prices being too high, output being too low, quality being low, lack of innovation. Those are things that I think if there were, I
didn't ask you about the tech companies. Like for example, I think in Europe, British Airways was found to have sufficient market power they had sufficient dominance to be abusive, and then were found to be using that dominance, and they had under 40% of the market. What's wrong with that as an outcome?
Well, I think often with an abusive dominance claim, and this gets to the core of the difference between the US and the EU standard, oftentimes you can conflate harm to a rival with harm to consumers. And so in the EU standard, based on my understanding of EU's abusive dominance standard, they find harm to rivals. The law implicitly assumes that in the long run, that will include harm to consumers. And so therefore that's sufficient to intervene in that market. If you can show they're dominant and that it's harmed a rival in some way, using tying or bundling or predatory pricing, that sort of thing, then you don't actually need to show consumer harm. And I think the main problem with that approach is that oftentimes the same kind of conduct that is pro-competitive and good for consumers in terms of lowering prices, bundling goods together, especially digital goods that are free to produce. Their marginal cost is zero. One additional unit of software is zero to produce. They often bundle them together. Consumers benefit from that a great deal. But if you're a company competing in a narrow vertical with one of the big tech platforms, often it feels to you individually like it's unfair, even though it's good for consumers. And so you'll file a complaint in Europe and say you're being unfairly targeted. But I think if we want the focus to be on consumers, which I think, especially low-income consumers, I think that's the best way to keep the focus.
But in your structure, if two companies dominate a marketplace in a combined way, let's say each of them has more than 45% of the market share. In your conception, they're not monopolies. Therefore, that concentration of power shouldn't be addressed by anti-competition law. Is that right?
No, I believe that any competition law includes things like collusion between large players. We can break up oligopolies. And so if there's any kind of price maintenance going on in those markets with little competition, you can definitely go after them. And what I would say is that when you look at prices in these markets, they're either falling or have been at zero for years. But one point I'll make is that the reason investigations and scrutiny is important is because having to look at private data can be helpful. I'm only able to use public data as I work at a think tank. Private data can maybe reveal things that I'm not familiar with. And you want to consider the counterfactual. And so maybe prices would have fallen even more in a different scenario with more players. But I just think it's one of the harder cases to make when, like previous witnesses have said today, I think there are clear cases of antitrust problems in things like hospital sectors and pharmaceutical sectors where you see massive consolidation along with prices increases, no increases in quality, real consumer harm that I think if state attorney general offices had more resources or the FTC or DOJ had more resources, under current law, those cases could be prosecuted. And I think they should be prosecuted.
But again, in your view, barring, in my scenario, if there are two, if the parties are genuinely independent, if there are two of them, say, and they're not colluding, your suggestion is that there shouldn't be a remedy through competition law.
Well, monopolization under competition law is only one sector. And so in general, philosophy, again, I have to come from the economist perspective. I don't have a legal background, but my understanding is that you look for effects-based outcomes. And so you compare it to the competitive level. And the competitive level wouldn't necessarily be just two companies. It's whatever an economic model shows is the competitive level. And then if prices are 5% or more above that, then you've shown actual harm to competition, to consumer prices. Adjusted for quality, adjusted for innovation, you can adjust for other things, not just prices consumers pay.
Even if they're not monopolies.
Yes.
Okay, thanks. My time's up, so I appreciate it.
Thank you, Alec, for joining us today and for answering our questions. Our next witness is, next and last witness is Christopher Marquez. Sorry if I slaughtered your last name, Policy Counsel for NetChoice.
Okay. Good afternoon, Chairman Thomas and members of the committee. Thank you for the opportunity to testify today about why I think the 21st Century Antitrust Act should not become law. First, a little bit about me. My name is Chris Marchese, and I'm Policy Counsel for NetChoice. We're a trade association that works to expand free expression and free enterprise online. Our members include names you know well, like eBay, Etsy, and Expedia, and names you know very well, like Amazon, Facebook, and Google. So as you might imagine, this bill is important to us at NetChoice. But more than that, it's personal to me as a fourth-generation New Yorker. In fact, I'm testifying today from my childhood home in East Islip. With the exception of a few relatives who defected to Florida, my family's all still here in New York, from Brooklyn to Babylon. So like you, I care a lot about protecting New York consumers. And that's why I oppose this bill. If it's enacted, it'll make consumer welfare take a backseat to corporate welfare. It does this in two big ways that we've touched upon many times today, but it's worth reiterating. First, it ditches New York's objective consumer welfare standard and imports Europe's subjective abuse of dominance standard. And second, it enforces these provisions by encouraging rent-seeking lawsuits by rival businesses. To see how this plays out, take my hometown. Like the rest of the state, we love our bagels. But in recent years, we've gone from having about a half a dozen or so bagel stores to just one, Stuff-A-Bagel. Stuff-A-Bagel's so popular that the line is literally out the door and around the corner just about every day, which is a little frustrating, but it's worth it. And the reason for that is simple. It makes the best bagels in town, and the other bagel stores just couldn't keep up. But if this bill were to become law, Stuff-A-Bagel could be sued by its rivals and prosecuted by the state. I know it sounds crazy, but even the Attorney General today testified that small businesses aren't necessarily safe. At best, as the Attorney General put it, it'd be unlikely and rare that the state would go after small businesses. That doesn't really inspire confidence because, as Ken pointed out, what if her successors don't share her commitment to protecting small businesses? Anyway, going back to Stuff-A-Bagel for a second, we see that the risk is real. Under the law, Stuff-A-Bagel would be considered dominant and its practices would be considered abusive. Not only does it bundle bagels with free coffee, it's leveraged its reputation with customers to expand into the pizza bagel market and the deli market. It's even taken away customers from the pizzeria next door to it and the deli across the street. Even more damning, it's expanded from East Islip to West Islip. All of this benefits consumers in my town, but under the abuse of dominance standard, it's not us who matter, it's the pizzeria, the closed bagel stores, and the delis. That's because under this bill, they'd be allowed to sue under novel theories of harm that put corporate welfare before our consumer welfare. And unlike in Europe, which is really worth noting here, Europe forces the loser of a lawsuit to pay the attorney fees for all sides. We don't have that rule in the United States, in this state, or in this bill. So we don't have any safeguard against frivolous lawsuits. Now, none of these concerns are bugs. They're all features meant to give the courts the power to apply their understanding of fairness, however they define it, however they see fit, and no matter the effects to consumers. But that's discretion that will lead to absurd results. Now, I get it. This bill is meant to target quote unquote big tech, but as I'm sure everyone here appreciates, all laws have unintended consequences. So what starts with tech won't stop with tech. All businesses in all industries in all parts of the state will be at risk. Even if the bill removes the private right of action, as Professor Wu suggested, the abuse of dominance standard will be weaponized beyond tech. After all, the state AG is an elected position, and it's likely that future AGs will run on platforms to go after successful companies for goals that are unrelated to antitrust but popular in the press. I'd also point out that if one concern the state has is about corporate power, a subjective standard enforced by an elected official is ripe for growing that power. And I'd also point out that even if the bills were refined to target just American tech, it will still hurt New Yorkers and all the millions of small businesses that use tech to grow their businesses, cut their costs, and reach new consumers. If tech businesses are at the mercy of a standardless standard, they'll do the rational thing and keep innovative products and services from New York. This won't be malicious, but it will be required by law. As the European Commission recently explained, when dominant tech firms do anything that could possibly change the status quo, that's considered abusive. So to wrap up, I'll end by saying that this bill gets to first principles. Should New York's antitrust law protect consumers or should it protect competitors? I hope New York answers the latter, as it has for the last century, and it will heed Judge Hand's other cautionary tale that size does not determine guilt. Thank you.
Thank you, Christopher. Senator Gianaris.
Thank you, Chair. I've only got 5 minutes, so I'll refrain from pointing out the absurdity of your Stuff-A-Bagel example and how it has absolutely no application to this proposal. But I do appreciate your anti-democratic screed, and I mean democratic with a small d, that somehow elected officials are ill-equipped or public accountability is ill-equipped to police our economy. Perhaps that's why we've got so many problems that we do have that we're trying to solve right here. I want to ask you, Mr. Marchese, who you're speaking for, I guess. You listed some of your members. We had other witnesses before who are part of the industry who testify that they are members of many of these trade organizations like your own, and yet do not believe that the leadership of those organizations speaks for them because they themselves are being dominated by the dominant players in the market to the detriment of the smaller players. So who are you speaking for today? Are you speaking for every single one of your members?
Absolutely not. I'm speaking only on behalf of NetChoice. To be certain, we have a lot of members and a lot of them do have conflicting interests. So what we do at NetChoice is we have promulgated broad principles that we make public. They're on our website. And we say to all of our members, these are our principles. Sometimes you will support them and other times you won't, but we will not change our principles to match your agenda. And broadly speaking, tech companies have a lot in common. They have a lot of similar interests, but they are not precisely the same. So I speak on behalf of NetChoice.
And so how does NetChoice determine when it takes a particular position when its members are conflicted about it?
So we actually, we focus on our principles and whether those principles are going to be implicated by something like this bill. So because antitrust affects the entire tech industry and industries beyond tech, this is something that we by default always get involved in, whether it relates to a specific member or not, because at the end of the day, even if a member isn't immediately implicated by a bill or an action, it could be down the road. And we are trying to preserve the tech industry, not just individual players within that industry.
Right, what I'm trying to get at is who's making that determination? The staff? Are you consulting with some of your membership? How is this, where's this coming from? Or is this just you, Christopher, deciding that the principles of NetChoice are inconsistent with this proposal?
So we do have internal discussions about it, right? So we follow the news, and this bill has made the news. And so we decided to reach out and have me testify. But it
Right, but I
really
guess
it's internal.
I am being difficult, but it's for a purpose. So who is the we? We've had ample testimony from members of the tech industry who said this is a good bill that would help them because they are smaller players in these markets, and that they specifically suggested that trade organizations like yours respond only to the bigger players because that's who funds your groups, and you're essentially AstroTurf spokespeople for them. I will note that again that they were invited and chose not to attend themselves, but send you out to tell us how elected officials are not equipped to make decisions like this. So who are you speaking for? Are you speaking for Google and Amazon and Facebook, or are you speaking for the real innovators, some of the smaller tech companies that are trying to make a living?
So Senator, I appreciate the question, and I would like to make 2 points. One, I'm speaking only on behalf of NetChoice insofar as our principles apply here. I was not asked by any specific member company. In fact, you know, as someone else noted, I think it may have been you, our member companies sometimes disagree. Facebook and Apple had a pretty public squabble. We don't, you know, we can't please all of our members. That's why we focus on our principles and we let our results speak for themselves. Now, second, I apologize if I gave the impression that I don't believe in our elected officials or in democracy. It's quite the opposite. I really do believe in democratic accountability, but what concerns me is that the government has a lot of power, and antitrust is an extraordinary remedy meant for an extraordinary problem. And as we've seen since the beginning of the Wilson administration, when there are certain questions of economic importance that are so personal, we sometimes trust independent agencies and independent experts to pursue those goals. I mean, you know, we have the FTC as an independent agency for that reason. And so the point I was trying to make is that when the state legislature promulgates a new law, it is best to make that law as, you know, objective as possible. Now, I'm not saying that it needs to be so narrow that it doesn't apply to any new circumstances that could possibly arise. I'm just saying that it's better to have an objective standard that can be enforced as objectively as possible by both the government, the executive branch, and the courts.
My time is up, unfortunately, but I just want to point out in closing that I wasn't suggesting you spoke specifically to the heads of these companies as it relates to your testimony. You don't need to. You know where the checks are coming from, and so you know where your opinion is going to lie without having to consult every time with Google. That's my point.
I don't think that that's an accurate representation, though. I mean, again, you know, our member companies have interests that sometimes conflict. My testimony today, whether it's good or bad, was a reflection of my own work and my own thoughts. Now, I admit that maybe the bagel store example didn't, you know, hit all the right notes, but that was something that was genuinely important to me to point out.
Thank you, Christopher. Senator Kavanaugh, do you have any questions?
Yeah, thank you. So I'll, pun intended, I'll bite on the bagel story. If your Stuff-A-Bagel is a customer of or has a business relationship with Grubhub or Uber Eats or Seamless, are those companies members of your organization?
No, I don't believe they are.
So again, you know, Stuff-A-Bagel had their innovative period where they were, you know, making the best bagel and expanding presumably to pizza bagels and then pizza and other things. But if we're looking at Stuff a Bagel's interests in this market, should we be concerned if the market is evolving, as many people where I come from tell me, such that it is very difficult to be a retail food operation without using those delivery services?
So Senator Kavanaugh, the first thing that I think is worth pointing out is that digital markets and digital platforms have allowed small businesses and small restaurants to reach more consumers than ever before. I mean, if you think back just like 5 or 6 years ago, it used to be the case that you would have to call up a store, place an order, and then you could go pick it up in person, or you could have it delivered. Now you can use an app, and it's pretty simple. I mean, yes.
And the store would keep 100% of the cash that is paid for the goods, whereas now some portion of that is going to these companies. But so in that example, should not without concluding whether the existence of those applications per se is good or bad, should we be concerned about the relative power of those delivery services relative to your local bagel store?
No, not at this point in time. I mean, I can't make a broad statement for the future, but something that I think is important to note is that in the past, a store could keep 100% of its profits from that sale, but it also had to pay the delivery guy his gas money.
Sure.
So
but just again, you're saying that you're doing a quick assessment and saying that at the moment those organizations don't have sufficient market power that we should be concerned, or are you saying that sort of per se we shouldn't be concerned about the market power of food distribution of delivery services like that? I mean, if let's say hypothetically, Seamless, Uber were to buy Seamless, and now you've got Grubhub and Seamless, Uber Eats merges its operation in, and now you have two companies, and we could demonstrate that each of them has significant market power, and that it's very difficult for your bagel store to survive without using those services. Should we be concerned about the implications of that power for the relationship between your bagel store and those companies?
Well, I think it's always, if there's a monopoly and the monopoly is abusing its power, yes. In this scenario, I think that there is, robust competition. Now, I understand in your hypothetical, you had two companies merging, but I think that merger would have to be evaluated under, what are the likely efficiencies that would be gained. I mean, we have seen in recent history that mergers, especially vertical mergers, and in some cases horizontal mergers, in fact, horizontal mergers are universally accepted at the federal level as being efficient because it cuts down a lot of the costs that those big businesses would otherwise have, and then they pass them on to restaurants.
I understand that, but so in the event that there are two companies doing delivery, and we were to concede that bagel stores and other people that are trying to provide food to people cannot really effectively run their businesses without those companies, we should not be concerned about should not be concerned about the price they're extracting from your bagel store, or we should only be concerned about it at the point where there's only one delivery company?
To be honest, I do not think that it matters how many companies there are or how big those companies are. What matters is the actual price that they're charging. So if they are charging,
but just another time, does it matter how much power they have in the market? Does it matter if they have a dominant position in the market?
A dominant position, no, because there are very low entries to barriers. So if Uber Eats were to jack up its price, a new competitor would enter the market. In fact, that is one of the things that we have seen in antitrust, is that when a dominant player jacks up the prices, it invites competition from other companies that ordinarily would sit on the sidelines because they see an opportunity to undercut that dominant player.
And so you reject the notion that was said earlier that once you have a network that has a good fraction of the market, it's hard that itself becomes a barrier to entry. It would be difficult to set up a new Seamless or a new Grubhub, given that those are already the platforms that are people using.
I don't think that network effects are as big of a barrier as entry as people say. I mean, we see, take Facebook. Everyone says it has massive network effects, and yet TikTok came along and has seen explosive growth. Now, granted, TikTok might be in a different position given everything else it's going through, but TikTok ate into Facebook's market share. And it came out of nowhere.
And has altered Facebook's behavior and made it more consumer friendly?
Yes, I mean, Facebook has, upgraded Instagram. It released Reels. I think that Facebook sees TikTok as a real competitor and has taken seriously that, TikTok offers things that my generation and younger seem to really like. And I think that Facebook is taking note.
Okay, my time's up, so I'll end it there. Thank you.
Thank you.
Thank you, Senator Kavanaugh. Christopher, I have a couple of questions. Number one, do you know that you're at a hearing with elected officials?
Yes, sir.
All right. So in your opening statement, when you kind of had a statement or two as to elected officials not having sufficient knowledge to introduce legislation, was that? What did you say?
I said that I worried that if New York were to pass this law, it would encourage future attorney general candidates to potentially weaponize and politicize antitrust, which is something that we have seen in other countries. I would never suggest that you and the rest of the legislature are not capable of investigating this law or to pass meaningful legislation. And so I'm sorry if that was the takeaway.
All right. Now, another thing, I mean, everything that you testify to right now, I find completely absurd, and it goes against a lot of facts that we have accumulated. Thank you for coming on. You were our last witness for this. I have no further questions for you. With that, I would like to thank everyone for their testimony today. It's been an immense pleasure to hear from everyone on this very important subject matter. I want to thank our Deputy Majority Leader, Mike Gianaris, for introducing this piece of legislation, because it's about time we updated our laws here when it comes to companies and them taking advantage of consumers. I want to thank my fellow committee member, Senator Kavanaugh, for being on as well, the ranking member, Senator Tedisco, who had to leave us, Senator Ramos, Senator Myrie, Senator Comrie, and I would like to thank my staff and central staff for all the great work that they have done. Thank you so much. God bless. And this was a great hearing.